Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
All right, good morning, everyone, and welcome to today's sitting of the Appeals Court. I'm going to begin by introducing the panel to you. To my right is Justice John Englander. To my left is Justice Christopher Hodgins. My name is Ariane Vuno. I believe everyone in the courtroom already knows that you have 15 minutes to present your argument and that there is no rebuttal in the Appeals Court. I always like to assure everyone that we have read everything that you have provided to us. 15 minutes is not a very long period of time, so you should get right to your argument or your best argument as soon as possible. And of course, you're not required to use all the time if you don't think it's necessary. All right, with that said, I'm going to call the first case, which is Commonwealth versus John Donovan, 2023-1010.
Good morning. Good morning. May it please the Court, Christopher DeMayo for John Donovan. I think I will take things out of order. I'll start and try to clean up some of the individual charge issues at the back. One of them is, we argued that the indictments for forgery of a notary are duplicative of the indictments for forgery of that document. In light of the Commonwealth's brief, I will concede that I went back and I didn't parse it out that fine, but it is true that if you make lists and cross them out, you get a couple on each side that aren't there. So I'm conceding that fact. I guess I'm not conceding the issue because as I read the cases, this court may affirm on any grounds that are apparent from the record. So to the extent it's discretionary, I think it's an interesting issue, and I think we're right for the reasons in the brief, but certainly the court may affirm on that ground if it wants. So otherwise, I'll say nothing more on that unless the court has questions.
Okay, thank you.
Okay. As to count 10, filing a signature under false pretenses, there's no evidence of a representation here. And as I understand the government's argument, it's when you give someone a piece of paper and say, please sign here. You're making an implied representation, and I'm not going to take this and go and alter it and forge it afterwards, which to me, that would be forgery, is the correct crime here if there's no evidence of an actual affirmative.
Why isn't it also, obtaining the document under false pretenses? You're handing the document to them, and why wouldn't there be with that an implicit representation? Hey, when you sign this is the document that is going to be the document that's filed, as opposed to, now I got your signature, I'm going to throw something else on it.
I mean, the crime of forgery is about altering documents. This crime, it seems to me,
crimes can overlap, though, counsel.
They can overlap. This crime is the classical case of obtaining a signature would be, I say, I make a representation. You write me this IOU, and I'll put it in the safe, and I'll never use it again. Or sign this letter that's written in French. It says such and such, and it really says you owe me $1 million. This just is not. I haven't found a case like this. You could interpret them to overlap that way.
But there is evidence in the record that what he signed is not what was actually filed. Correct?
That's what he said. Yeah, cloture.
But, I mean, there's evidence from which a jury could find that something was added to that document before it was filed.
That's
a handwritten note.
That's how he testified, yes.
Okay, all right.
Okay, so it seems to me, I don't know why it was charged this way, but it seems to me it's a forgery count. So moving on to the evidentiary issues, I know the court knows the record, so just to briefly recap, before this case came about, there had been prolonged civil litigation going on for years and years. There was arbitration. It didn't go well for Mr. Donovan, it's fair to say. He had many millions of dollars 20 years ago, and he doesn't have anything now. So he wanted to keep out that civil piece of that, and he was fairly vigilant, or his trial attorney was vigilant about filing motions and so forth and objecting and trying to keep that out. It crept in several times, I would submit, and we're arguing the cumulative effect. The government argues, well, this was fleeting and vague, and that may be for maybe one of them, but when you take it all together, you hear, that it was ruled that this power of attorney was not legitimate. We recorded something of the arbitrator because he had messed up our land grant, and we had to file something for this to go forward. James Donovan, the son, says that's not real, that's invalid. When you put them all together, I'd submit it's not fleeting, it's not vague, and
But the defense conceded in the opening and argued in the closing that there were forgeries.
He did.
Just not by the defendant. So this wouldn't have come as a surprise to jurors to hear that there was some question about the documents in another proceeding.
Well, it wasn't clear. As I argue in the brief, some of the documents are more important than other documents. The two ones that seem to me the most important are the power of attorney and codicil, because you could argue that gave you authority to do other things. There was a lot of evidence from the notaries who had no axe to grind, really. They were unlike a lot of the other witnesses that no, that's not. I never sign in blue. That's I always sign in black. That's not mine. So there was some vagueness over what was real and what wasn't real, and I guess that was a deliberate choice of trial counsel. But hearing that these important documents had already been adjudicated, or maybe not explicitly, but strongly implied with these repeated objections, and I appreciate there were motions to strike, and he struck them, but I think the principle that a curative instruction works, that has to be the case when it happens one time. But when it happens repeatedly, I haven't seen any cases that say that. It's kind of counterintuitive when you keep hearing.
Joel, do you have any cases where, because I wrote a case called Silva that you might have seen from this court, and I think there's a sentence in there that says we're aware of no case where it's been held to be error not to declare a mistrial when there is an instruction that's contemporaneous and firm.
But
disregard the evidence.
As I recall that, well, you know better than I, Justice Englander, but I think that was probably about one particular bad thing that was said. But what I'm arguing here is you had throughout the trial, and I get that it was a long trial, so the argument is, well, by the second week they might have forgotten that this had been said.
I take it your answer to my question is you're not aware of a case where a judge's refusal to declare a mistrial was overturned, where he gave an instruction immediately. I mean, in each of these instances, the judge acted, each of the instances you raised, the judge struck and instructed, right?
Yeah, I mean, the Creighton case, there are lots of cases that question the efficacy of curative instructions when it's on an important issue, and I haven't found a case, and that's why I think this is an interesting case, is sort of this seriatim, the same thing, 3 or 4 or 5 times. It seems to me it's completely counter to why. The first time you say disregard that, presumably the jury can, but when you hear the same kind of question, same kind of answer on the same topic for the 3rd or 4th or 5th time, and you hear disregard that, then
Are they all of the same
well,
magnitude? I mean, the first one I get, because it was a declaration of the ruling by the arbitrator, if you will. But after that, they become, what you're concerned with become increasingly vague, right? Including the statement that I'm aware of an invalid. I mean, that doesn't reference a decision by an arbitrator at all.
Yeah, I mean, why else would it? The argument was, well, that's just his personal opinion, which does, I mean,
he was in a position where somebody was handing him something.
Yeah.
And he was concerned that if he didn't say it was invalid, he would be taken to. I'm inferring this from the way he reacted. He was concerned that it was going. If he didn't say invalid, he was going to be in some way putting his own imprimatur on the document.
Well, he was asked a factual. I mean, I could look up that particular page of the transcript, but as I recall, James Donovan was asked. He was handed the document and asked a factual question. He's a fact witness, so his opinion.
Have you seen this document before? And he's like, yeah, but I think it's fake.
Yeah, I mean,
if he doesn't say that, then there's an implicit. It's not fake, right?
And I don't think the one about the arbitrator from the lawyer, Samasco, we recorded an order of the arbitrator. There'd just been testimony that he filed some bad things that had thwarted this land deal, and, we recorded an order of the arbitrator, which allowed it to go through, which suggests that, again, it's just reinforcing the earlier one, so I don't, if you took any one of them, yes, maybe after the first one, you could say they're fleeting and vague, but we credit juries with all these, they can tell if you're lying or telling the truth from your body language, and they can read complex 40-page jury instructions. So it's not clear to me why they couldn't put this together after it happened 4 or 5 times. That's really the gist of that. But to get back to your question, Justice Englander, and there are cases, like I said, that question the efficacy of limiting instructions. But I couldn't find a case exactly raising this issue, which is an interesting one, which is it's a similar thing happening over and over with the, so that's interesting. The video issue. This was this defense counsel made a big deal of this video and this guy in Ireland who was going to say, and what he wasn't allowed to make an offer of proof. The judge didn't want to hear it. It seems to me that at least there should have been some kind of a voir dire, but you can tell what he would have said because it's in the Commonwealth Supplemental Appendix. If you read the Edelstein report, McInerney was going to say that I was a dupe. I gave them some money, a little bit of money. I didn't give them $150,000. And then I found out about this years later, and I saw things that had my name on them that were forged. So that could have been helpful for the defense. Given the whole defense here was sort of, like I said, it was a mix. Some of these things are real, and some of them have been faked. So it's always a tough argument when you have to argue that there's a conspiracy out to get you. But in this case, if you're going to make that kind of argument, this would be the case. You're dealing with a lot of sophisticated, rich people who have a lot of enmity going back years. So if you look at it in that scope.
Articulate for me what his testimony would have added to the defense case.
Well, it would have brought out that one of the bullet points on the codicil, Exhibit 12, was legitimate. It would tend to legitimize that codicil.
The bullet point is one that says something about that the father is provided with the authority to file some kind of voluntary thing with the tax authorities, right?
Yes. And I guess if he had been allowed to testify about, I didn't hear about this until there was arbitration. Well, we didn't want to talk about arbitration, so I don't know how he would have handled that. But I didn't find out until years later that my fake signature on all these documents. That could have been helpful if the argument is that that someone faked these and Mr. Donovan is saying it wasn't me, and that's more modus operandi than anything I saw in this case.
But didn't the lawyer, though, come in and testify about the Bermuda Trust and the tax implications and so forth? So what would this witness, by Zoom, have brought to the table that the lawyer didn't already put in front of the jury?
Well, he would have established as a factual matter that this is true. I didn't pay them the money. Neiman, the expert, just said, I'm told this, and if this is the case, it's just a kind of classic conditional expert testimony that if this is true, then this follows. But if I were on the jury, I would have been wondering, well, because they kind of built this up. This is a real foreign grantor trust if the guy put $150,000 in it back in the 90s. And if he did, and it's not. So everything kind of hinges on that, and he never showed up. So that's, I guess, the damage. And the bit about the forgeries.
Well, wouldn't the judge, the judge expressed he articulated some real concerns, it seems to me, about allowing testimony by Zoom, right? Especially in a case of this sort. The jury doesn't get to see him. I don't have a way to control him.
Yeah, no, I appreciate that, and there's some argument in the Commonwealth's brief about this shouldn't happen as a matter of course, and that's not our position at all, that this should happen as a matter of course. But he had, I think, a prima facie good reason, if you look in the impounded index, that the guy really was ill. I get that they're accusing Mr. Donovan of fraudulent things, so everything could be fake. It could be fake medical records. The guy on Zoom could be an actor with an Irish accent. I understand these are issues, but he didn't really go into it at all. At least I would submit, in this case where it's an important witness and there is a Sixth Amendment right to present your case, there should have been at least a voir dire to see if this was feasible, and it was just kind of cut off. And if I were a juror, I would have been left wondering what happened.
Your time's running down. And I don't know where you want to go next, but can we talk about the SIL evidence that went in?
Yes, that's exactly what I wanted to do.
How did that happen?
So, to me, I think this was just completely inappropriate. Mr. Donovan, was running this business back in 2016. SIL came into this case a little bit because, the two young people who were the key witnesses, Paulina Park and Ben Kuhl, the immunized witness, said, well, we did all this forgery while we were working for SIL. And that was pretty much it. Ben Kuhl said one thing. He said that he made a passing comment that I talked with this attorney up in Vermont who would wire money to Mr. Donovan's personal account. Now, that sounds kind of untoward, like they're commingling funds or something. So when the attorney Tom Hayes testified, there was like two questions, just to clarify. We needed an account up in Vermont. Donovan had an unused account, and we dedicated that to SIL. That was the end of it, and then they talked about a lot of other things. Mm-hmm. And then when this SIL...
Who put in that evidence? Who put in the evidence about the account that you've just articulated?
Well, like I said, Ben Kuhl mentioned it. So
No, but was that the prosecution or the defense?
No, the defense. I mean, Hayes was the prosecution witness, but when he was cross-examined, they just asked this a couple of questions about about that one account. There's no discussion of the finances or billing or expense reports or any of that stuff. It was completely irrelevant as far as I'm concerned. The judge seemed to say there's no foundation even that he had anything to do with this, so it's irrelevant. And he said, you did open the door. He didn't open the door, I submit. If you read the testimony, if you read the Hayes testimony, he didn't open it. Can you open the door to prejudicial, irrelevant evidence? I don't know that you can, but even if you can, he didn't do it here, I would submit.
Sometimes it happens, but let me be sure that your question's been answered. Any further questions over here?
Thank you.
Thank you very much, and you can rest on your brief for the remaining issues. Thank you.
Good morning. May it please the Commonwealth.
Morning.
Well, Catherine Jansen on behalf of the Commonwealth. Let me try that again. I totally misspoke. May it please the Court, Catherine Jansen on behalf of the Commonwealth. Tongue-tied this morning. I think I'll start with that SIL issue, if the Court would like. And the way that this came about originally is the Commonwealth absolutely did initially want it in for modus operandi pattern of conduct. And then there was a voir dire of the forensic accountant, and it came out on the voir dire that the documents provided were provided in part by the defendant and other board members. And so based on that, Judge Chippy found that, there's not really a foundation that if he had been the sole provider of them or, whatever, had the ability to manipulate them and the only person, then potentially there would be foundation for the MO. However, so he excluded it on that. So it didn't come in as a prior bad act. It came in because the defendant on cross of Hayes brought up multiple transcript pages talking about invoices, the defendant having contracts, and basically trying to establish the legitimate business operations of SIL. And Judge Chippy reasoned, I think, that this...
Where is that evidence? So this is the opening the door argument, right?
Yes.
So where is that evidence that you've just described? Where will I find that?
So you'll find it from transcript volume 8, 53, through really page 80. There's an objection in the middle of it because the Commonwealth objects to relevance, and the defense attorney says, well, he kind of opened the door to potentially the bank account being untoward or potential impropriety when Ben Kuhl, in passing, just kind of mentioned it.
Oh, it's defense introduced evidence to the effect that there was legitimacy to the SIL documentation and bank accounts.
Correct. And like invoice, because he's talking about invoices and that the defendant had.
Implicit in that was that Donovan himself, the defendant, was responsible for these various corporate records.
Implicit in that, correct. However, when Judge Tibby allowed it in to rebut this proposition, so it didn't come in for a prior bad act, nor was it.
How does it not come in as a prior bad act?
Well, one, I would suggest that there was no explicit reference or suggestion that these modifications were improper in any manner or fraudulent by the forensic accountant. That was not brought out. And nor was it one ever argued as a prior bad act by the Commonwealth to the jury. It wasn't mentioned again.
Why they put it in? I don't understand why it goes in. Why does the prosecution want to put the evidence in if it's not to have the jury infer that Donovan was engaged in fraud with his company?
Right. I mean, I think hindsight is 50-50, that its probative value is tenuous at best.
50-50 is like really good.
But I think the reason why the tenuous relevance that we're talking about is why it's not overly prejudicial, because it's not linked to the defendant. That was elicited on cross-examination, that he was not solely responsible for providing these documents, and they came from everywhere. And again, there was no mention or suggestion that he created these modifications by the Commonwealth. Even if you're concerned about a potential bleed-over inference the jury may have had, it, again, was a very small piece. If we're going to go to the prejudice argument, it was a very small piece of the Commonwealth's case. It was not argued that way by the Commonwealth, and I would submit there was overwhelming evidence that the defendant had forged these documents. They were everything contrary to his son's estate wishes, which he had professionally prepared documents by a myriad of experts, that even if he wanted to keep his relationship with his father secret from his family, he would have theoretically disclosed that to his attorneys, who he has attorney-client privilege with. And, you know, you have direct evidence from Paulina Park and Ben Kuhl, as well as not only that he had them dictate these documents, but then had them transfer signatures to them, but also that he had the opportunity to do so based on the database. And so I would just suggest, in light of the nature of this case, even if perhaps if this case were retried, this wouldn't have happened this way, I don't think it warrants reversal in this case. It doesn't amount to prejudicial error.
What about the sort of repeated references? The judge was pretty upset. I think it's pretty rare to have a judge say, I think that the professionals are conspiring to put in something that I have said you should not put in.
So I want to go back and address what the actual ruling was in the motion in limine. It was that it wasn't that there can be no mention that there was an arbitration or arbiter. That didn't come until transcript volume 9, page 11, I believe, before attorney Henry Sullivan testified. The ruling was that you just can't say that what the arbitral finding or ruling was, which is the defendant had forged these documents filed in the Registry of Deeds. So to that extent, saying that you couldn't even discuss it, that was not what the ruling was initially as the trial went on.
Not contesting that it should not have been said. I mean, the judge had to intervene and strike it.
Correct. I would say probably the most problematic would be Rebecca Brown, which was the first one. She's not a professional witness. She was the defendant's daughter, and she was testifying originally about helping the decedent with his estate plans. And then on cross-examination, the defendant brought out the 2002 power of attorney and brought out that she did not view it as legitimate. So that was already out there. To the extent there was no evidence in the cross about the ruling, when the prosecutor, again on redirect, was trying to clean up the Vermont codicil and going through bullet point about why these bullet points weren't consistent with his estate plan. Part of it, what I think the prosecutor was trying to get out, was that not that there was a ruling that this was viewed as legitimate, but that it was contested whether this 2002 power of attorney was legitimate. So I just want to clarify about what I think would be the most egregious problem, and that was at the first day of trial, and it was immediately struck, and jury was instructed to disregard. To the extent that these other people, I mean,
What difference does it make whether or not she was a professional witness or not a professional witness?
To Judge Englander's question, saying that the attorneys were conspiring, that these professional attorneys who were...
that was the judge's impression, but no.
Right. So I was just mentioning that it was the inference, because maybe I'm mischaracterizing, my understanding of Judge Englander's question was that the judge was pretty upset because he even went so far as to say that he was afraid that the professional attorneys, meaning the Mintz Levin attorneys and those people, not the siblings, were.
I take your
Yeah.
point.
So-
The worst of it didn't come from what the judge was
Correct.
referencing as
And-
professional witnesses.
And I think, again, the Conadaris and James, one was talking about a codicil, one was talking about the power of attorney. Conadaris only said, this is wrong. He's like looking at the addresses and stuff. That doesn't say a judicial ruling. That's his opinion. It was struck immediately. Same with James. He's saying, well, I think this is invalid. That had already come out by the defendant on cross of his sister. And no mistrial was moved for after that. And James was the last one for James or Conadaris. And then as far as Attorney Signal, that was unexpected, and nobody knew who Judge Martin was. They knew, the jury was aware that there was ongoing litigation in the civil side, so it's not a shock that there might have been a judge involved, but didn't say there was a ruling. And then as far as Semesco, about the land deal, again, this is why we have to rely on the trial judge's discretion, who's there hearing the evidence come in, and I would point to the fact that the judge said, just because the transcript picks it up because they're talking into a microphone doesn't mean it's amplified in the courtroom. And the judge said, I couldn't really understand or hear anything but the word arbitration or arbiter. So it wasn't even clear that an order of an arbiter was even really before the jury. And the judge was in the best position to determine the prejudicial effect of that. And again, the judge acted promptly and forcefully each time. And then the length of the trial, the first instance was, which I think was probably the worst, concededly, was at the first day of trial, and the next one wasn't until like a week later. And then there were, due to the nature and complexity of this case, I really don't think it would seize the attention of the jury in the manner that the defendant would now suggest.
Let's talk about Zoom. Is it the Commonwealth's position you can never have a witness testify by Zoom in a criminal trial?
No. No, I think,
So, but certainly, given that there's a constitutional right for a criminal defendant to put on a case, if we accept the notion that sometimes there can be Zoom hearings, and the defendant says, this is critical to my case, so how do we go about thinking about that then?
well, I think what you have to do is, there's not an absolute right always to just say it's critical to my defense. I think the judge has to make a ruling, as he did here, or a consideration based on the nature of the case, what the proffer is. He had a proffer about what this was from the defense attorney multiple times, that whether or not this was highly relevant or tenuous or really necessary. And I think that occurred here, and I think that's the balance you need to strike when you're looking at the right to present a defense. It's like, I would suggest it's akin to a limitation on the right to cross-examination, potentially. So that type of analysis, if that's helpful to the court.
Limitation on the right to cross-examine. Well, I suppose that limitation could be you don't get to cross-examine. That would be, that's essentially what happened here. You don't get to examine this guy. This evidence is gone.
Well, this was, his relevance was completely collateral and tenuous at best. As the judge noted, it's only relevant if, for two things have to be true. That John III, the decedent, actually received a distribution from...
Wasn't there evidence from which the jury could have found that?
Yes, but there also has to be evidence that he did not pay his taxes, and there was no evidence that he didn't pay his taxes. Even if you take the expert attorney Nyman, which the Commonwealth elicited for the defendant, essentially, that there was evidence that he had this distribution, and then also elicited for the defendant that McGurney would say it wasn't a true foreign grantor trust, so therefore it's a sham. There was no evidence that he didn't pay his taxes.
Well, but can that be inferred? So the defendant's position is that the document is real, right? That the codicil itself is real. Can you infer from the codicil that he didn't pay his taxes? He's got a tax issue. That's why he's granting his father the authority to solve that.
I would suggest you can't even infer that from the codicil, because if this is one single bullet point and all those bullet points and everything else in that codicil is completely contrary to everything else in that state plan, including the fact that it reaffirms that 2002 power of attorney, and then 2 days after that codicil signed, he signs a codicil.
But now you're just asking me to infer that he's guilty. That's not the context in which the judge was making his ruling on whether the evidence could come in.
I don't think that, I think I maybe a little got lost in your question then.
No, I mean, the answer I heard you give is you can't infer from the first paragraph of the codicil that he had a tax problem, because the remaining paragraphs of the codicil are fraudulent. Isn't that what you were sort of saying?
Right, I don't think you can just look at the codicil and make an inference that it's real because the Commonwealth's position is the whole codicil is fraudulent.
Of course.
So I don't think one bullet point creates that inference, and then you can't make that inference on the flip side. I mean, at the end of the day, the defendant got out this evidence, and he was able to use it and argue it. So there's no prejudice in this case.
Yeah, I mean, my point was simply that when we're examining whether the judge committed error in not allowing the witness to testify, I think we have to take positions from the defendant's perspective as long as those positions have some reasonable basis.
Understood. I don't think I necessarily understood that was the point of your question when you asked it.
But in any event, your point is that even viewing it from that point of view, you're saying is that it's just not prejudicial because of the fact that the substance of the testimony was essentially presented to the jury.
Absolutely. It came in with the benefit without potentially damaging cross-examination by the Commonwealth. So he got the best of both worlds.
Am I correct of your argument as sort of an even-if type argument?
Correct. It's an even if. I think there was no error here in the judge in weighing the right to present the defense, because I think he's looking at one, the evidence that there is no evidence, really, it's speculative at best, even in light most favorable to the defendant, that he got that distribution, but two, that there's no evidence that he didn't pay his taxes on it, but two, also that it's really not, I don't really think it is the centerpiece of the defense, and if it's really it's gonna basically make it so he has no defense at all. I don't think that's the case. So I think there's no error in that, but even if the court were to disagree with me that the judge did not look at it in the proper fashion.
Well, how would you articulate what the defense was, separate from this notion that the codicil and the power of attorney are real? And here's at least some evidence we're going to present of why the codicil is real, if you will.
Right, so it was in his view that the power of attorney and the codicil were real even if they weren't actually valid. However, but there was also the defense that he had this falling out with the founder of SIL and his son, and they had the means and access to create these fraudulent documents, and that was part of the defense, that these documents were forgeries. So,
Okay.
That's why it's, not the only, I think that makes it less important, quite frankly. I see my time is running out. I'm happy to answer any other questions the court may have.
And I'll check with the panel. None here? None here? Okay, thank you both very much
Thank
for the
you.
arguments. Okay. The next case on our list is Commonwealth versus Christiane Mara, 2023-1142. Good morning.
Good morning. May it please the court, Amy Cottignon on behalf of Christian Mirage. At the outset, I wanted to address the argument number 3. On review of the briefs, I am withdrawing that argument from the court's consideration today, as I don't believe that it any longer has a basis. So I'd like to withdraw that argument. I'm asking that the court reverse Mr. Mirage's conviction. And I'd like to address first the alternate juror issue. Mr. Mirage was denied his right to a jury composed of a fair cross-section of the community when the sole person of color who was on his seated jury was designated as an alternate over his objection. Case law in the Commonwealth and also from the United States Supreme Court recognizes that diverse juries are an important feature of the right to a fair trial. And here, the judge had discretion to designate the alternate, or remove the alternate rather, from consideration as an alternate. This person is the only black juror. Mr. Mirage is a black person, and it's the only juror of color. That representation was made by defense counsel. It was accepted by the court. Counsel asked that he be removed from consideration from the alternate draw, and the court responded, I do not have discretion to do that. I'm deciding this as a matter of law.
And relying on the statute.
Purportedly relying on the statute, but I would suggest to this court that the statute actually does provide two mechanisms from which the judge could have removed this person from the alternate draw by exercising his discretion. The first, the plain language of the statute says that the that the foreperson is not considered as an alternate. So they are removed they are not put in the barrel for the alternate draw. So designation of this person as the foreperson would have been entirely appropriate by the judge. The second is...
Just to be clear, that wasn't suggested to the judge at the time, correct?
So that exact mechanism was not.
Okay.
But it's plainly within the statute.
No, I understand. I just wanted to be sure. Okay.
Yes, so counsel did not sort of suggest the mechanism from which the judge should do this, but as indicated, there are two different ways the court could have done it. The second is by way of stipulation of the parties, which is sort of towards the end of the language of the statute, which says that, we can...
Again, though, not suggested. Not even suggested in your brief, as a matter of fact.
I believe that was suggested in the brief, but regardless, it's within the statute, and counsel...
It wasn't suggested at the time. Counsel came and said, look, I think you should take her out of take this juror out of the pool of people who could be selected as an alternate, right?
Yes.
But there was no reference to the fact that perhaps my brother or sister will agree, nothing like that.
There wasn't, but the court sort of shut down the conversation. And of note, the Commonwealth didn't object to what counsel was requesting. And so what I am suggesting would have been appropriate would be a review of the plain language of the statute. But the court indicated I do not have the discretion under the law to do this. But there's a statute on point.
Well, is it possible that the judge was referring to this language in Batson v. Kentucky, where the Supreme Court said, by denying a person participation in jury service on account of his race, the state unconstitutionally discriminated against the excluded juror? That regardless of what the statute said, if you pick someone because of his or her race and say that you won't be deliberating on this jury, isn't that a denial of that person's constitutional right?
I disagree with that characterization for two reasons. First, that's dealing with the jury pool and selecting a person based solely on their race. Here we have only one person who's made it through this process, who's a person of color onto this jury, right? And the second thing is the court is not saying, I mean, there's 11 other jurors who are going to be seated on this jury who are white people. So it's not discrimination against any other person because of their race. It's simply acknowledging the reality that people of color bring something important to fairness, not only the perceived fairness from the public, but also the fairness of the deliberations generally. So it is not to say that we are excluding white people as a group from this jury. There's 11 deliberating jurors.
What you're suggesting is that because this individual is not the same color as the defendant, that the judge had the discretion to remove him from deliberations on the case. And that seems to be exactly what Batson discusses about the court's unceasing efforts to eradicate racial discrimination, and in fact referred to Justice Frankfurter's dissenting opinion, where he said a person's race simply is unrelated to his fitness as a juror. But you're suggesting that it is.
I am suggesting that that is inaccurate. The aim of Batson, the aim of Soares, and again, Article 12 is more protective than the federal Constitution. The aim of those cases is to guarantee a defendant a deliberation by a diverse jury, or as fair an approximation.
Whoa. To guarantee a deliberation by a diverse jury. I think we have cases that say explicitly that is not what Soares says, and that is not what Batson says. Right? Am I right? Cases explicitly say that.
You are correct. And what I was saying was as fair.
So when you say that's the aim, and I know the cases say exactly the opposite. What do we do about that?
So what we are trying to do is as fair an approximation, and that's what I was trying to say, as fair as an approximation as the veneer allows. So here, the only person...
The cases are about fair cross-section. They're about the jury veneer, right? And there's no suggestion in this case that the jury veneer, I mean, there's no argument that the jury veneer didn't represent a fair cross-section of the community.
There's not, but there's also
Okay.
not in the peremptory challenge cases. So Soares, for instance...
Say that again?
There's also not in the peremptory challenge cases. So in Soares, for instance, where we have people of color who are struck and not able to sit on the deliberating jury, that is the error. So not all of these cases deal with the pool from which we can pick. The question is the impact on the jury that deliberates on the defendant's fate.
Yeah, but the peremptory challenge cases are, okay. The peremptory challenge cases are about an exercise of peremptory challenges based upon the race of the juror, right?
So some of them are.
They're just flat discrimination cases, is what you would say. They're not fair cross-section cases.
Well, some of them are and some of them are not. The Kalia case from
Yeah, I'm familiar with it.
I know you are, Your Honor. I did see your concurrence, and that case is not necessarily about discrimination. So the cases are about the impact on the deliberating jury, and I think that for us to pretend that, you know...
Kalila isn't about the impact on the deliberating jury in any way that you're talking about. That was why I wrote the concurrence. Kalila is a case where the black person was allowed to sit on the jury, and somehow the court still threw it out.
I understand the court's point. But my point is that there is literature and there is research that shows us that having people of color on a jury results in a more fair and just verdict.
That sounds to me like an argument that says we should have petite juries that reflect in some exact fashion percentages of the population.
There's no case law that supports that, and that's not what I'm arguing.
But other than that argument, how would we go about doing this?
We would go about doing this by saying a judge, on request of a defendant, has discretion to remove this person from the alternate draw, to allow at least some representation.
But the piece that's there, counsel, that's really critical is, and it was error for the judge not to exercise his discretion to leave this person on the jury because of this particular person's race.
So,
that's your argument, right?
Not exactly. My argument is not that it was error for him to exercise his discretion, because my argument is that he didn't understand he had the discretion to exercise. And that is a mistake of law, which in and of itself is an abuse of discretion.
Well, he had discretion under the statute to do two things, even as you've articulated it, right? Which
Yes.
is to make this person, appoint this person as the foreperson.
Yes.
And I'm forgetting what your other possibility was, but
The stipulation.
The stipulation. So you're saying those two things are part of, or innate to the statute, and by not recognizing that, the judge erred.
Yes.
Had the judge said, for example, I think I have discretion to do these two things under the statute. Had the judge read the statute himself at this point in time and said, I can do one of these two things, but I am exercising my discretion to not do them, would your argument be different?
I think it would. I think it would have to be. I think it would then be an abuse of discretion standard. And I think there are many reasons.
And is there anything in here that would support, in your view, an abuse of discretion, if that had been the case?
In this case, no, because there's no findings expressly about, it could be a situation where the judge says, I don't think that person was paying attention, or, for whatever reason, there's many reasons why that wouldn't be an abuse of discretion, but here the court didn't think he had the discretion to exercise. And I think that's the distinction, because if all jurors are equal, which here they appeared to be, the literature and research tells us that inclusion of even one person of the defendant's race, or of any, a different race.
Are you making a discretion argument now?
I'm sorry?
Are you making a discretion argument now?
If I need to prove prejudice, I think that's the prejudice. Is that the court's question?
Yeah, so you're making a prejudice argument. The point you're making out of the social science is a prejudice point.
That is a prejudice argument, yes.
Okay.
But what I would say is that the courts designate four people in cases for various reasons. You'll see
Right.
cases where a judge says, that's a business person, I've seen them be
College
very
degree,
attentive.
et cetera.
You're saying it has to be done as a matter of law.
That's not what I'm saying. I'm saying that judges have discretion to do this, and it is an appropriate consideration for, what I'm saying is that the court can't blind itself to the fact that people of different races bring different things to the jury room. Their experience, but also the way in which people of different races react to them. They bring different things to the jury room, and that can be an appropriate consideration for a judge to say, we want fair and impartial deliberations.
Can we just back up? Because I'm trying, it's helpful to have you articulate the argument the way you have. So your first argument is the judge committed an error of law because he thought he did not have discretion.
Right.
Yes.
Okay? Now, as to that argument, ordinarily we would ask the question, how was that legal point presented to the judge? Was the judge given the opportunity to consider that legal point? So I'm going to ask that question directly to you. How was the legal question presented to the judge? Because we've already established that there was no request to appoint this person as a foreperson, and there was no request to stipulate, right?
Yes, counsel did not outline for the court how counsel wanted this to be accomplished. But what I would suggest is that there is a statute directly on point that deals with designation of a foreperson, but also how the alternate draw should happen. So we can infer that the request would have been, applying that statute. There's only one law on point. So I think that this court can appropriately consider that to be preserved. The request was made, I think, 3 separate times, and what the court said is the law does not allow me to do this. So I think inferably the court is referring to this sole law that's on point. There's one statute on point. And I'm suggesting to this court that that's an error of law.
Yeah, but,
Is it in, go ahead, sorry.
I'm sorry. I'm just still troubled just by your premise here that, and this is one thing that, as a lawyer, when you are finishing up a case and it comes time for the judge to pick an alternate, it always comes as a surprise to the jurors that, we're not going to be deciding this case, that
Yes.
a couple of us are going to be pulled out of this. And you can see the disappointment on their faces, that they've invested their time and their effort in the trial, taken time out of their lives to hear this case, and they're told that they're not going to be deciding it. But they seemed okay with it when the clerk rolls that barrel and sticks a hand in and just randomly picks out a number, and that person then is deselected from the jury. But it's an entirely different matter. And don't you think it would be an entirely different matter if instead of rolling that barrel and pulling out a number at random, the judge said, you're not going to decide this case because you're not the right color?
I don't think that's what I'm asking.
That's exactly what you're asking.
So what I'm asking is that the judge could have said, in seat number 2, you're going to be the foreperson, and now we're going to select the alternates. Pick 2 people. It has nothing to do with you're the one person who's not going to deliberate the case. The alternate would...
But by selecting someone who's the right color, you are necessarily deselecting someone who's the wrong color, right?
I suppose so, but the goal is one that is necessary to address a systemic harm in our criminal justice system. We have had sort of a pattern of unfairness of our criminal justice system towards persons of color. And when we know, the research tells us, that inclusion of other races in jury deliberations, you will have a more fair result. I think that that's an important prospect.
One last question, and I know that your time is up. Would you be advocating instead, or in addition, a change in the statute to make it clear that the judge has discretion along the lines that you're articulating now?
So I think that this court can make that determination because the plain language is there within the statute. This court can make a
Plain language,
determination.
the plain language is that the judge gets to pick a foreperson. It isn't the judge gets to pick a foreperson, but the judge must make that decision on the basis of race under
I'm
certain
not asking that this court.
I am afraid you are, because
so
because you're asking us to declare that the judge committed error by not picking this person as foreperson because of their race. That's what the opinion is that you're asking us to write.
I'm suggesting that
Am I
race-
right that that's
No,
what we?
not in every
How am
case.
I not going to write that if I was to write the opinion?
Because the court would be acknowledging that the court had discretion to do that on a variety of factors, that race is but one factor for a
And the
juror.
error was?
And the error was not understanding that the court had the discretion to take a person from the alternate draw.
And the error in this case was not choosing this particular person for this reason.
Because it deprived the defendant of a discrete group on his deliberating jury.
I'm
And I
just
would
going to sum up with one thing. I think that your position is slightly larger, which is it doesn't necessarily have to be a juror of color, but could be a juror with some other attribute
Right.
or non-attribute.
The court
Is
has
that what you're
discretion.
saying?
That is the
All right,
record
just
of
wanted
fact.
to be sure.
And in the Soares case, just for the record, and I understand that I'm out of time, in the Soares case.
Last point.
One juror was removed, one juror that was of color made it onto that jury, and that person was designated as the foreperson. And I think that we can infer that that was a decision made by the judge. That everything else, every other person of color.
Oh, that's
was
always a little
back
bit,
and straight.
okay. We'll go with
I'm
that.
sorry.
happens.
I need to understand this now. So the argument goes beyond race.
The argument that the court has
The
discretion. to-
argument you're
Yes.
making goes beyond
It
race.
does.
So if it's a Hispanic defendant,
It goes
if
beyond race
it's
generally, yes.
what to any of the protected classes?
Gender, but I mean, the court has the discretion to do this, not even dealing with protected classes. The court has the discretion to do it. You know, if the court can designate a foreperson because they've been paying attention, because they're a professor,
An
for any
attribute.
reason. Any reason. And I would rest on my brief on the other issues unless the court has further questions.
No, I'm all right now.
Okay. And how about you?
Thank you.
Thank you very much for your argument. I know that we push sometimes with our questions, but we do that so we can understand the issue well and be able to articulate it when the decision comes out. Thank you. Counselor.
Good morning, Your Honor. May it please the Court, Caleb Schillinger for the Commonwealth. Justice Hodgins, I'm not familiar with the Madsen case, but I did have in mind a different Supreme Court case, which is the decision they issued last year striking down Harvard and UNC's admission processes. I think that case made clear that picking winners implicates the Equal Protection Clause just as much as singling out losers. And the result the defendant advocates for here, which is either removing somebody from the alternate draw, or even if the judge were to designate someone as the foreperson on the basis of their race, implicates the Equal Protection Clause and does not fall within either of the two very narrow categories that the court has held survive strict scrutiny.
Let's talk about the sleepy juror, because I think that judges worry about sleeper jurors quite often, or jurors that aren't able to really focus. You think that never happens, that juror is taken out of the infamous barrel that gets rolled? In your experience in court, has that never happened, that a judge has decided that somebody who is not paying attention should be an alternate in a case?
Sorry, Your Honor, should be an alternate.
Should be an alternate, exactly, so that,
Correct, and that also would be an irregular selection of a juror, right, inconsistent with the statute. And so my point here is simply, Your Honor, the judge followed the statute to the letter in selecting the alternate jurors.
What do you say to counsel's, the way counsel has framed the argument today? I think your opening point is extremely relevant, and obviously not in the briefs at all, but extremely relevant.
Right.
And because of the way this argument is unfolded. Sometimes argument changes things, right? So your opening point's extremely relevant, but your sister says, look, he committed an error of law because he said on the record, I don't have any discretion as to how to do this. The statute gives me no discretion. And she says, well, yes, he did. He could have picked this person as a foreperson, or he could have sought the stipulation of the parties. What do you say to that?
They're two different things. He had no discretion in terms of the selection of alternates. Now, he did have the authority to select a foreperson, and I cite, a case for the proposition that there's no law currently that constrains the judge's selection of who should be the foreperson. Again, I don't think it would be appropriate for the judge to do it solely on the basis of race, but set that aside. Judges can pick the foreperson of the jury. Those are two different things, and the defendant did not ask this judge to select the juror in seat 2 as the foreperson.
Okay.
So even if you come back and say it's an abuse of discretion, it's a substantial risk standard, and there clearly was not a substantial risk of a miscarriage of justice here for the reasons that I've laid out in my brief, including ultimately the verdicts that were rendered here by the deliberating jurors, where they convicted the defendant only of the offense that was uncontested and supported by overwhelming evidence.
Yeah.
So you can't conflate the two and say that his failure to select this person as a foreperson constitutes a violation of the statute.
Let me get my questions out, because I'm trying to understand it. What do you say are the two different questions? I need to understand your point.
Correct. Selection of alternates is different than appointment of the foreperson. They're dealt with in two different statutes, and you can't graft one onto the other to say that
no, but the selection of alternate statute references the foreperson.
That they are excluded from the draw, but the selection of the foreperson
So
is dealt with.
they are interrelated. I mean, whoever wrote them understood the interrelationship. The foreperson doesn't go into the draw for alternates. So that's a known thing, right?
I guess I would fall back to, Your Honor, even if you are willing to conflate the two and say that his unwillingness to remove this juror from the alternate draw constituted an abuse or implicated the discretion that he had to select this person as a foreperson. It wasn't asked for. It's an unpreserved error. It goes to the substantial risk standard, which the defendant cannot establish in this case. But they are separate inquiries. I don't think it's appropriate to conflate the two and say that not removing
Is it
them
an
from...
unpreserved error? I mean, counsel came to the judge at least once, maybe twice, and said, please don't put, I guess it was just once, please don't put this juror in the pool.
Yeah, it is an unpreserved error because it's not the judge's obligation to divine a solution not suggested by the defendant. Now, it is clear that the defendant wanted this individual to remain a deliberating juror, but the judge had no obligation to sua sponte figure out the way to achieve that result would be by selecting this person as the foreperson.
What does the case law say on the judge's discretion with respect to the choosing of a foreperson? You mentioned it in your brief, but I think the suggestion is that it's basically plenary discretion, right? It's unreviewable.
Obviously subject to constitutional requirements, and so again, I think that, doing what the defendant wanted done here would be a violation.
One of which would be not to choose them on the basis of race, potentially, in any direction.
Correct. Exactly right, Your Honor. But I think the court can stop short of that because, and I think the reason it wasn't addressed in the briefing, although it lurks in the background, obviously, is there is no right, as part of a right to a fair and impartial jury, to be guaranteed a deliberating juror of the same race or ethnicity as the defendant. You have the right to a jury drawn from a fair, from a veneer with representing a fair cross-section of the community. The defendant does not challenge the process by which the veneer was constituted, doesn't challenge the resulting composition. I think that's fatal to his claim. And beyond that, I would just note, as counsel mentioned, even if his claim were meritorious, which it's not, the relief he'd be entitled to would be a new trial, not reversal of the conviction, because the evidence here was obviously not only sufficient, but was in fact overwhelming. Unless the panel has any other questions, I'll rest on the arguments in my brief.
No further questions, so thank you very much.
Thank you both. Very well argued.
Okay, we're going to go on to our third criminal matter that's on for this morning, Commonwealth versus Kevin Murphy, 2023-1248. Good morning.
Good morning. May it please the court, William Corman on behalf of Mr. Murphy. I do want to take half a second just to note that Mr. Murphy, who is incarcerated, his entire family is present today, which is not something we see all the time, so I'd be remiss if I didn't point that out to the court. There are two issues that I set forth in my brief. I'd like to address the second one first with the court's permission, which really has to do with the Commonwealth filling in a gap in the evidence by essentially fabricating testimony during the closing argument. The Commonwealth literally pulled something out of thin air and threw it in closing argument, and I would suggest, obviously, that that's improper in any way, shape, or form. This is, I want to say anecdotally, my fourth or fifth case where I've dealt with sexual assault matters and closing arguments that I would suggest are inappropriate on behalf of the Commonwealth. I tend to channel my inner Justice Brown, who, as we all know, talked about closing arguments all the time. Here we are again in a case where the evidence was such that there was no forensic evidence in this particular case. It was a credibility contest between the defense and the Commonwealth, and I would suggest that by an improper closing argument in this case, the Commonwealth firmly put their thumb on the scale, and I think, with all due respect to the government, it's time that we hold them accountable for that.
But the evidence that was in the record as of the time of closing indicated that the defendant had touched the victim's chest.
That was the evidence that had come in, Your Honor, yes.
Okay. And when the aunt, I got to get this right.
It was an aunt and a mother.
The mother testified as to what they said to the defendant that day. They said, I told him I had concerns.
Correct.
Okay. But we know that from the evidence and the admission of the defendant that was more than just I had concerns. It was that there had been a touching.
Correct.
Is that sufficient to infer that more was said, including what the prosecutor said in closing argument?
Absolutely not, Your Honor. And the reason is this, is we are, in that case, we're inviting the Commonwealth to say whatever they believe we can infer. And the evidence is the evidence.
No, they can argue any reasonable inference from the evidence.
Then I would suggest that that certainly isn't a reasonable inference to make. That a mother says to her father, right, to her father, the biological grandfather of the child, I have concerns.
Well, but we know she said more than that.
We do.
Because the recipient of the statement tells us that she said more than this.
The aunt,
Right.
correct.
Right.
And then we have the victim's testimony as to what she said.
Which is considerably more vague.
Which is, I thought, more detailed.
No, I would suggest that the victim's conversation with the aunt, and this, now we're sort of getting to...
Right, because it's aunt to mother.
We're bootstrapping into my first argument, which had to do with the fresh complaint. Yeah. The victim's testimony about what she told her aunt, going back to my first argument, or my first issue, is pretty thin. The victim testifies as the victim testifies, but the victim's testimony about the facts and circumstances surrounding her complaint, the first complaint to the aunt, is pretty thin. The aunt then,
What does she say? She says, he touched me.
He tried to pull my legs apart, I believe is, or he tried to open my legs, and then the aunt...
Wait, that's...
The victim, right.
That's the victim?
That's what the victim says. The aunt then is allowed to, I would suggest, improperly testify as a first complaint witness to a litany of a very understandable, mind you, but not proper interrogation that she then goes into with the child, saying, did he do this, did he do that, did he put his fingers in you, did he put anything else in you? And she is allowed to testify to this over and over and over again. So Justice Englander, getting back to your question, I don't believe that we can allow the Commonwealth to claim this was a fair inference.
But we have to get the evidence right. So the daughter says, I do remember I ended up telling her that he touched me.
Yes.
Okay. So, all right. And then there is a reference in the next question specifically to breasts and vagina, to which the witness answers yes.
Yes, Your Honor, but I don't want to disagree with the court, but I think we have the chronology. I don't think we're aligned with the chronology, because what the Commonwealth talks about in their closing argument, the statement is, CP, the mother, if you will, told her she called her father after learning this information and confronted him. The mother says, the victim says she touched her breast and her vagina, and his response was, I'm sorry for anything she thinks happened, so on and so forth. That never happened. The victim's mom never says, the victim says you touched her breast and her vagina. The Commonwealth is...
The question I've asked is, was that inferable from the evidence?
Correct.
So I would suggest that, well, the answer is there was evidence that the defendant touched the victim's vagina. There was evidence to that. I don't think you can infer that it happened during that conversation.
Right, the crux of the matter is that the prosecutor misstated what the mother said to the defendant.
Correct. So
that's it.
So I don't think we can.
And what Justice Englander is trying to point out is, well, could that, although it's a misstatement,
yes,
that's been conceded by the Commonwealth.
Yes.
Was there still evidence in the trial of these two touchings? I'll put it that way. Okay?
Sure. The answer
is yes.
The answer to that question is yes. There was absolutely evidence of the two touching.
Okay.
Hands down. But again, this is where sort of how I started out my argument.
Actually going further than that.
I apologize, Your Honor. I couldn't hear you.
I said I'm going further than that. I mean, the Commonwealth has conceded error. I understand. I'm actually asking the question, should they have? Because you have, what I just read from the record is the daughter's testimony. You have the father, I'm sorry, the grandfather, the defendant.
Defendant, yes, Your Honor.
Conceding, okay, that he was, that mom said to him more than mom actually testified to. So mom testified, I have concerns. Father grandfather, defendant concedes he touched. She told me something about that the victim had complained that I touched her.
Yeah, he doesn't admit to it. He admits.
Then you have the victim's
what he's told.
testimony as to what she said.
Yes, Your Honor. And I suppose I'm.
What she said to her aunt.
Right. There's a lot of steps.
I agree that it's.
And what I would suggest to the court is that I disagree respectfully with Your Honor. I think Commonwealth absolutely should have conceded error here because the Commonwealth isn't allowed just to plug in. Again, the Commonwealth is essentially, I look at it this way, the Commonwealth is basically saying, quote, it's almost as if they take a chalk, if you will, and they say in their closing argument, this is what you heard from the mom, quote X, and that's wrong. That wasn't what the evidence was. So that's the problem. It's not the Commonwealth saying, ladies and gentlemen, you heard evidence of these multiple touchings in this variety of way. Yeah. It's the quote that's the problem. And I would suggest that it's the quote, the chalk analogy just came to me, I would suggest that it's the quote, that's where the problem lies. So of course the Commonwealth has to concede error because that never happened.
And then the question is, how prejudicial is the error?
And that's where I get back to what I said before. This is, like so many of these cases, it's a delayed disclosure matter. There's no forensic evidence. The testimony, I would suggest, again, if you take a giant step back, we have a prior mistrial. We have some acquittals. The testimony is a mess. We have multiple layers of he told or she told this to the aunt, who then told this to the mom. It's a confusing ball of evidence, if you will, for lack of a better phrase. And it's within that context, I'm suggesting to the court, that the Commonwealth has to be careful as to how they proceed in closing arguments. That's their obligation.
Well, there's no question about that. And of course, they agree with you on that. They had to be careful, and this was, a misstep. It was the second trial. I mean, I think it was the same prosecutor in both trials, and things were different in the first trial. So whatever. But we'll let that one go. I'm still trying to. The prejudice that you are emphasizing is because it's a classic case of credibility and a classic case of where there's no forensic evidence.
And that the Commonwealth, again, as you just correctly stated a moment ago, the Commonwealth is the one with this obligation here, and defense counsel can't make stuff up in a closing, but the Commonwealth has an obligation to present the facts as they are. And doing so and straying from what I would suggest is a narrow tightrope.
I don't want to throw you off here, but I'm persuaded that the Commonwealth had this balled up in the closing. That's pretty clear. But in my mind, the question is, what do we do about it? What is the prejudice? So if we just assume that this was wrong, Commonwealth got it wrong on a number of different levels, it looks like to me. What, if any, remedy is there for this?
It's a new trial.
But why? Why would that be? Because does that mean that if the judge has instructed the jurors that, now I want to remind you that whatever the lawyers say is just argument, and you're to focus on the evidence, the testimony, exhibits that were offered, that's what I want you to focus on, not on the openings, not on the closings. Does that have no effect at all?
I don't believe it does.
And why?
And because, we're going back to the classic unringing of the bell, if you will. In this particular case, which doesn't always happen, there's an objection to the closing argument. The judge sort of essentially says, I'll cover it in my boilerplate instruction. And I know that we assume that juries follow the instructions, so on and so forth. But when there's a particular instance, as Your Honor said, where the Commonwealth has made an error, and that error is brought to the attention of the court, I think that the next step is that the judge gives a specific instruction that you are not to consider the statement of the Commonwealth that X, Y, and Z. That was an error, and I'm asking you to not consider that whatsoever. If that had happened, if there had been a specific instruction tailored to this particular error, I don't think I'd have an argument. I'd probably still make the argument, but I don't think I'd have a leg to stand on.
Was there a request made to highlight that particular statement by the prosecutor and to indicate to the jury that that was not correct?
So what counsel ends up saying is he tells the court, he objects, he says that that's an error, and no, he does not take the next step, basically saying, you need to do this. You need to specifically instruct the jury that they should not consider.
Nor is there an objection to the jury instructions.
Correct, correct. And that I can see that that's a problem, but nevertheless, I think that in cases like this, where it's brought to the attention of the court, I think that should be the next logical step.
But we have so many cases that say, if the defense attorney did not ask for something specific, then we can then infer that it wasn't as egregious as it seems to be in hindsight. We have cases that say that time and time and again.
We do.
And what makes this case different then?
I think that, first of all, I would suggest that in this particular instance, we have an objection to a closing, which we don't always have. Oftentimes, it's appellate counsel who goes through the closing and says, oh, here are some problems here.
Well, there's a fair share of them, but we're still...
I'm going to say 50-50, but okay.
We're still in a different situation right now, which
Yes.
is, it appears as if counsel was satisfied with the jury instruction.
I think that counsel didn't object to the jury instructions. I don't want to make the inferential leap that counsel was satisfied with the instructions. But
All right, I'll take your words. There was no objection.
correct. Absolutely. I agree with that, Your Honor. I agree. And I'm suggesting that this court then takes it further. That this court basically says when there are errors like this in these types of cases where it is a classic he said, she said, no forensic evidence, no percipient witnesses other than the victim, that something more needs to happen. Because otherwise we have this conversation, the four of us have this conversation again next month and again a year from now and so on and so forth.
No, I argued plenty of cases before Justice Brown, so I'm familiar with his comments on this issue.
But they hold true. They absolutely hold true because
he was
here
very
we are.
articulate, yeah.
So, help me with this on the prejudice issue. Let's assume that I agree with you that there's an error in what the prosecutor said, which is at least, and we'll just stay here, that the prosecutor said, so-and-so, the mother told you this. The mother didn't tell you this, so that's false. But the jury could infer that the mother did say that. Does that make a difference in terms of your prejudice argument?
No.
Why not?
Because the jury can infer, the jury can infer that the mother did say this?
The mother did say that because you've got the defendant saying something more than the mother did, right? The mother says, I told him I had concerns, but the defendant says, oh no, there's something about touching.
I don't think it changes the prejudice. I don't, because again, I fall back on the Commonwealth has an obligation to give a fair closing argument. And I could stand up here and say, because they have the weight of the government and, the burden's on them and so on and so forth, and anything they do to put their thumb on the scale matters. And the only way we can hold them accountable is to find that there's prejudice in cases like this and overturn the verdict. Thank you very much.
All set. Thank you.
Good morning. May it please the court, Kyle Sikanolfi for the Commonwealth. I'm joined here today by trial prosecutor Allison Portney. In terms of the scope of the error alleged by the defendant on appeal, we are talking about 4 words over the span of a 16-page argument. And we are talking about an argument that was delivered and followed by robust instructions that emphasize to the jury that their memory controls. Particularly, that was cautioned to them 4 times after the closing argument, including a specific correlation that if the juror's memory differs from that of the attorney's, the jurors are to rely on their own recollection. So this is not, I would submit, a boilerplate or brief touch on the issue. The judge's instructions emphasize the jurors' memory controls, that they decide the facts, and that evidence comes only from the witnesses, and of course that closings are not evidence. So this
I don't understand the 4 words. It looks like more than 4 words to me.
I would say it's the characterization by the prosecutor that the mother's allegation, confrontation of the defendant, included vaginal touch. So the statement, victim says, "You touched her breasts." That's supported by the evidence, as the panel has discussed.
Well, not entirely, because your argument in your brief was that the defendant testified that that's what the mother had said, using the word breast, but that's not what, at least the evidence I looked at, he just used the word chest, right? Or that there was a touching.
I believe it's a specific reference to touching of the chest while in bed. So when I say 4 words, I'm referring to
All right,
the
which
and
do you have
vagina
the transcript
stated twice.
page you're referring to? I apologize. I jumped around a bit because there's so many different witnesses who bear on this question.
Which witness would Your Honor like me to direct the attention to?
Oh, I see. Yeah, you're right. He was impeached by his prior testimony, and at that point, they used the word chest, right?
Yes, I rolled,
Yeah.
she came in, got into the bed, I rolled over and
Transcript
touched her chest.
4172. Okay.
Yes.
All right. So you do have that.
And to that end, the statement is erroneous, the Commonwealth's position in the brief, the statement is erroneous as to, and touched her vagina. So the vaginal touch being,
Well, no, it's erroneous it's also erroneous for the reason that your opponent emphasized, which is it says the mother told you this. Explicitly says you have the testimony of the mother. And the mother didn't say that at all. She didn't come close. She said, I told him I had concerns.
well, I think fair reading of the closing argument is the prosecutors capturing the conversation and of that phone call, and the defendant's
how about this
evidence.
If I could, how about this as a fair reading? A fair reading is that the prosecutor was trying to make it look like the defendant had admitted to the touching. It's presented as an admission. I said this to him, and then he said, basically, I'm sorry. So the two together is the way it was presented. Mother's
statement
to him, his response.
Sure.
It didn't happen that way.
Well,
right?
we do have evidence from the defendant that it was the mother he spoke with on the phone, and that she relayed the allegation of breast touch.
Right, but he didn't say, and I apologized.
He did, Your Honor, and so did the mother. They both testified
He
to his
testified
apology.
that he apologized?
I believe so.
That same evidence?
It certainly appears in the mother's testimony, but I believe he...
Right. That's my point. But if he admitted to it, that makes a difference too, I think.
I'll have to add, my memory is that he did of course, in his direct testimony, denied that that had occurred, but did express.
Yeah, I don't see it in what I just looked at, but I'll look for it.
But I think, I don't know that even if I'm wrong about that, it coming from the defendant, this was a marshaling of the evidence in closing argument, and these were pieces of evidence that the jury had, that a conversation took place on the phone between the mother and the defendant, that there was evidence that the allegation was made of a sexual touching, a breast touching while in bed, and there was evidence that the defendant's response to that was, "I'm sorry for whatever she thinks happened." That expressly was the mother's recollection of his account of her account of how he responded to that allegation. The argument, therefore, is proper in terms of marshaling the evidence and the reasonable and possible inferences that flow from it. The Commonwealth did concede in its brief that to the extent that it includes a reference to vaginal touching, the Commonwealth took the position that that was a misstatement of evidence. I do think an argument can be made that it's a fair inference from the evidence that an allegation of vaginal touching did reach the defendant, because we know the victim reported, "I told my aunt he touched my breast and vagina." And we know the aunt said, "I told her mother exactly what she told me." And then we know from the defendant that what mother relayed to him included an allegation of breast touching. So I do think there's an argument to be made that it's inferable that the victim's words about the vaginal touching ultimately reached him, but recognizing that that's more attenuated, of course, than the evidence about the breast touching. The Commonwealth took the position that that was a misstatement of evidence. However, it's not one that's amounting to prejudicial error, and that's because of the robust instructions that I was referencing earlier, that, as Justice Funo, I think, pointed out, there was no specific request for there wasn't a request for a more specific instruction or a assertion that this was some egregious misstatement of evidence that would sway the jury. As the panels recognized, counsel appeared satisfied that the judge's instructions on memory were sufficient, did not raise an objection to the instruction as given, or request some more particular relief. And I believe that that reflects a recognition by the parties in the room who saw the trial unfold that this was not something so egregious, certainly not something to warrant a request for a mistrial, because it was so tangential to what the parties were really litigating in the case.
You said that. This kind of goes to what I'm thinking. I'm trying to understand what the prejudice might be from this. So I'm trying to understand in my mind, why would the prosecutor have said this to begin with? It wasn't like a misstatement. It was said for a purpose. So what was the purpose of sort of implying or suggesting what a conversation might have been when there was no evidence what that conversation was? What was the edge the Commonwealth was trying to get here?
Well, I think that there was evidence of what the conversation was, but I think that in terms of how it was argued to the jury in the closing, the Commonwealth did seek to establish the defendant's consciousness of guilt. What if the effect of hearing that allegation of a sexual touching was on him, and how he responded in an odd manner, and arguing that contrary to his trial testimony, not only did his response amount to, "Gee, I'm sorry for whatever she thinks happened," but he didn't say any of the things that he included in his trial testimony about how it would have been impossible for it to have happened. All the things they did that day, all the places that they went. So the prosecutor tied it to his odd response, his lack of dispute at that time comparatively to how he disputed its possibility at trial, to say ultimately, altogether, would an innocent person have responded in that way? So the Commonwealth did use it as consciousness of guilt. And the misstatement as to what particular sexual assault allegation or words to establish the sexual assault allegation the mother used was really only important for the purposes of that this was an allegation of sexual touching and that this was this person's response. So it wasn't so essential the specific words the mother used so much as what was conveyed substantively about
I see,
the nature
okay.
of her quote-unquote
So
serious
it wasn't used, it
concerns.
wasn't used to sort of like fill in a gap in the Commonwealth's case somewhere, that we're going to slip this in and suggest this was evidence when it really wasn't.
And I would say certainly not, particularly because there was direct evidence of the allegations from the victim herself, of what touchings transpired that underlied the charged counts. I think also that there was other evidence that the jury was considering in this case. This tangentially touched on the ultimate issue in the sense that its credibility. The jury's going to have to evaluate whether to credit the victim, the supporting Commonwealth witnesses, or the defendant and his supporting witnesses' testimony. But it wasn't at the heart of the defense theory of the case. The defense theory of the case was this allegation only arose so that the victim could deflect attention from her own behavior. She only said it to get out of trouble. And even the people who knew her and loved her best didn't believe her. And that was his whole strategic approach to the case. And so this didn't, hew anywhere near that central issue for the defense. So I would say it's less problematic as a result.
By this, you mean the misstatement?
Yes. When we evaluate ultimately
He took
whether
the
it
stand and
affected the jury.
testified it never happened. And the argument that was being made by the prosecutor was he admitted it. He admitted it. He was confronted with it, and his response was, "I'm sorry." That goes directly to the heart of the case. Case has been tried once to a hung jury, and now an argument's being made to this jury that he admitted it, that has a predicate that's factually wrong.
Well, I think that to characterize it as an admission is to overstate its value. While the Commonwealth argued it for purposes of consciousness
Would
of
an
guilt.
innocent man say that? Those are her words, not mine.
No, I understand, and that's certainly how it was presented to the jury, but the jury's also presented with what the actual words are, which are, in the context of a co-sleeping family, sharing a bed, that he rolled over and is accused of touching her. And is that so implausible? Is that such an odd response to say, I'm sorry for whatever she thinks happened, even by the Commonwealth's evidence? I suppose what I'm trying to say is it's not so damning a piece of consciousness of guilt evidence that
That's a non-prejudicial argument.
and I am making a non-prejudicial argument, in terms of what its relative significance was in the scope of the case.
Okay. No questions.
Seeing no further questions from the panel, thank you for your time.
Words out of my mouth. I see no questions from the panel either. So thank you both very much, and thank you for answering all of our questions. And we appreciate it.
Thank you.
We're going to take a brief recess now, and the court's going to be set up for our fourth.
Good morning, council. Can you hear me? We're just going to do a quick audio and visual test here. Can you hear us? Do you mind just speaking so we can just hear you?
Good morning.
There's a little bit of a lag. Can you hear us?
Yes, I can hear you. Can you hear me?
Excellent. Yes, you can. We can, yes. So perfect. We're going to set you back within the waiting room, and we'll be starting argument in a few minutes.
Thank you.
Thank you.
All right, thank you, everyone. Let me call the case first, and I'll be sure that we have everybody here and that everybody can hear one another at the same time. So, of course, this case is impounded, so everyone please be careful and not use any real names. Case number 2023-1250, Department of Children and Families versus Mother and Another. So, with respect to the appellee attorneys, each person is taking 5 minutes. Is that correct? One? All right. And we have one person on Zoom. I'm sure they've already checked to be sure that you can hear us. And just say hello, make sure that I can hear you.
Hello.
Perfect, thank you very much. Okay, please go ahead.
Good morning, Your Honors, and may it please the Court. My name is Attorney Michael Penta, and I represent the appellant mother, who requests that this Court vacate the decrees terminating her parental rights. Although I raised 4 arguments, at the heart of mother's appeal, which is at the heart of every appeal in child welfare cases, is the state cannot permanently sever the constitutionally protected parent-child relationship unless the state's evidence of parental unfitness is clear, convincing, and current. Anything less is an affront to a parent's constitutional rights and the integrity of the trial process itself. In this case, as argued, the judge's subsidiary findings are not only sparse, but based largely on outdated evidence. And the subsidiary findings cannot adequately support clear and convincing evidence of parental unfitness. And because a parent must first be found unfit by clear and convincing evidence of current unfitness,
What would have been better than what happened? I mean, how are they not to do evidence that's outdated under the circumstances? The DCF called the mother didn't come. That's not outdated evidence, by the way.
well, the mother's failure to appear and testify at trial can subject her to a negative inference, but that negative inference is only on the evidence that's adduced at trial.
Well, but the fact that she didn't come is not outdated evidence. That's as current as it gets. We asked her to come and explain why she should not have her rights terminated, and she chose not to.
Your Honor, what you're asking is that the burden is then shifting to the parent to dispel the old evidence that the department has placed before it. And the reality is the department has an obligation to present clear and convincing evidence of current unfitness. The department could have called the social worker to update the record. They could have submitted a court report to update the record. They elected to do neither. All of the evidence before the court, so what we're left with is mere speculation, impermissible speculation and presumptions that the circumstances of 6 months earlier are the current state of affairs. But I do thank the court for I'd like to invite myself to elaborate on what the record was about 6 months or 8 months before that. The department social worker, because a lot of this is going to center around, of course, the argument of whether there was legal or factual abandonment, I assume, and that in 2000, I want to direct the court, it was in volume 4, pages 135 to 138. It is a court report from April of 2022 where the social worker had met on 2 occasions with mother in her apartment. Mother had explained to the mental health services she was engaged in. She signed releases. She had reported that she had a restraining order against the father of the children. She had asked and inquired about the children's education. She reported that she had a recent Zoom call or virtual meeting with the children and had asked for visits. And the social worker reported to her the children don't want to visit with you. The older child doesn't want to visit with you. The younger child is receptive to phone calls, and please respect their wishes, which the parent did.
Is that in evidence?
It is.
What you just said? What is that through a report?
It's the department's documentary report. All this is based on documentary evidence, Your Honor.
So what you articulated as to the actual statements, what she was told about the children's positions, that's in that report?
That is in that report, Your Honor. Again, I direct the court's attention to volume 4, pages 135 to 138. That is meetings between the social worker and my client in her apartment during home visits after she had filed for a review and redetermination. And that was the report that she was given back, that the children do not wish to visit with her at this time and to honor or respect those wishes.
So that meeting, when were they?
It's cited in my brief. I do it.
Of 2022, is that?
April of 2022 is Exhibit 45, but specifically pages 135 to 138 within that exhibit, in the volume, in the record appendix. Thank you, Your Honor.
Let me ask you a question about the exhibits.
Yes.
What are we to make of them? In other words, if, we have a pile of exhibits that get introduced without objection, but if there's no findings as to any particular exhibit, what do we do with that?
Well, I submit to your court that it is the trial judge, not the appellate attorneys on appeal, the appellate court on appeal, to make the specific detailed findings for the judge. With documentary evidence, they speak for themselves. I don't think the court has to make any significant deference to the judge's findings. I do submit to the court that the judge made very sparse findings nonetheless, based on this record. I submit that there is an integrity to this process that the department, again, bears the burden of proving current parental unfitness by clear and convincing evidence, and if it's doing so in documentary evidence, the document should be current and reflect the actual circumstances, not rely on a court to speculate what the evidence is now based on what the document evidence was then. I submit to this court that it's stale evidence unless the department produces current evidence that there's continued vitality of all of that conduct. And I submit to this court that the record doesn't bear fruit to that because there is recent evidence, at least in terms of between the review and redetermination and the actual hearing, when my client was engaging in some services. And I do, again, resorts to another argument that was raised about.
Well, before you go there, let me just continue with this. So as far as that document you're referencing, volume 4, page 135, did the judge reference that?
Well, the judge references the exhibit. The judge, in fact, probably only relies on about a handful of the exhibits of the 49 submitted. The judge does, in her 5-page findings, which are more reflective of skeletal findings than what we're probably accustomed to in the specific and detailed nature of these cases, does cite to the exhibits that she resorts to in supporting her finding of fact. So Exhibit 45 is one of the exhibits she cites to, so it's clearly...
No, but I mean the particular page that you're talking about in the particular conversation that you're talking about with the social worker, what did the judge make of that conversation?
As far as the findings are concerned, nothing. I didn't see anything where the judge... it's the department's report of what happened. I mean, it's their... But
we don't know, so we don't know what weight, if any, the judge gave to that.
Correct. And I submit to the court that the court is not bound with respect to the deference on these documentary evidence. I mean, they speak for themselves. The judge made no credibility determinations on the evidence. In fact, the credibility determination would be whether the social worker was credible because it's her report. And she's reporting back to the court the conversation and what she reported to the mother. So in other words, she's acknowledging the mother requested to have visits with the children, for example, and she's acknowledging back that she said the children don't want them. Respect that. She, in those pages, has said she called some of the service providers.
Are you claiming that that's clear error?
Well, I'm saying that the evidence...
well, maybe not clear error is the wrong thing. Are you claiming that that was a misrepresentation by the social worker?
Oh, no, not at all. I'm taking the social worker's
so why isn't that a perfectly reasonable response to mother's request, 3 years after she last saw the children, to start seeing the children again? Why isn't it a reasonable response for the social worker to say, I'm sorry, your children don't want to see you?
I'm not saying that's an unreasonable response, but it does go to the heart of context of whether my client has abandoned her children when she comes back and says, I was in a tough place and now I've gotten some help and I'd like to see my children. I just had a Zoom call with them and my daughters, and the social worker says, sorry, but we can't accommodate that because the children don't want to see you. And if the parent respects those wishes, and see how it can be held against them that that's a sign of abandonment when the parent requests and is denied that opportunity. I think you're
that happened in March of 2022, so that was 3 years, 2.5 years after she had last seen the children, right? What was you mentioned there's evidence that she had been participating in services. Where is that? Because I don't recall that being referenced in the briefs.
It's in the same passage I just cited. It's in the...
What services did she participate in?
She was engaging in mental health services. She had signed a release for the social worker to speak with her providers. The social worker described reaching out to some of the provider. It's within the context of the citation when the mother had visited with, or had a Zoom call with the children, or had a virtual.
Yeah, I don't understand the conflict in the evidence on that. So you say in your brief, no, it's not true that the children were abandoned because mother had this video conference and had actually visited in person with the children. And the other side says, no, that never happened.
Well, Your Honor...
And the judge says that never happened.
Mm-hmm. But all of that context is 6 months before trial. I mean, the department is, at the end of the day, there is a requirement or an obligation under the well-established jurisprudence of the appellate courts that the evidence must be clear, convincing, but current. And in this case, it's a document dump to the court based on evidence that was somewhere between 12 years and 6 months, where there's some evidence within the department's records that the mother had surfaced. She didn't vanish, and she sought treatment, came forward, filed a review and redetermination. It was allowed based on the changes of circumstances she represented.
But then she withdrew it.
Then she withdrew it in order to establish a relationship with her children first, and that was what was roadblocked when she met with the department.
When you say in
later.
order to establish a relationship with her children first, where is that? Is that what? Is that in the record?
It is in the record, Your Honor. If I can cite later to... I don't
It's
want to
in the
waste my
record?
time. It is in the record. It should be in my brief as well, Your Honor. I believe that she had withdrew it specifically. I'll be honest, it's in the motion itself, so it should be somewhere within volume 1.
Okay, all right. No, that's fine. We can
That
find
should be
it.
within the representation by counsel, that's why they were withdrawing the review and redetermination.
When Judge Griffin made the unfitness determination back in 2019, were there any findings of fact, rulings of law connected with that?
Not that I'm aware of in the record. I don't know if there was any, I don't know if there was anything from the bench, but there's nothing in the record as to written findings as to why she... And I admit that there was a concession of unfitness back then. The evidence was likely current. And in this case, we have a 6-month gap where the evidence is not current. And it's really not a hard gap to fill. It would have been to call the social worker to testify as to what the circumstances. I mean, we're speculating the social worker would have said, I called her every day. I did all of these things. But there was no action plan in place. The department's taken the position they had no real obligation to work with the mother because the permanency plan at the time was guardianship. And in fact, she wasn't a guardianship. There wasn't a...
That position incorrect?
I'm sorry?
Is that position incorrect?
I don't think the court needs to address whether the department had an obligation to. I would submit to the court, though, the answer to that, because I don't really know the quite answer to that. Typically, I know in practice, when the department accomplishes its permanency...
It goes to your issue number 4. Are you withdrawing that issue?
I'm not withdrawing it. I want to put it in context. Because if the department doesn't have an obligation, then the factors to assess on termination require that the department had offered services. So if the department takes a position that it didn't offer services, that is not obligated to offer services, then factors 2, 4, 5, and 6, which require as a condition for parents' lack of engagement, assuming that's the case, we don't know because we have a 6-month gap here, but assuming that's the case, arguing for purposes of argument, then the department hadn't offered services. So they can't have their cake and eat it too and say, well, we don't have an obligation to offer services, but when we terminate parental rights, the fact that we didn't offer services should be, part of the analysis. It shouldn't be. So I would submit that it's either the department had an obligation...
Well, but this is a review and redetermination problem, right? So the timeline is the children are removed in 2018.
Yes.
And then they don't immediately go to a permanent guardianship situation, right? Mother stipulates to unfitness. The children are put into the department's custody. They then go into the custody of whom? the people who want to become permanent guardians? Is that how it works?
So,
Here's what the punchline of the question is. Isn't the issue of whether the department attempted to offer services during that time period, isn't that the time period that we care about? Because once permanent guardianship is ordered and occurs, then the permanent guardians have rights, right?
right. So I would say that in that gap, it's obviously the department has accomplished its permanency goal. There's no longer needs for permanency plan hearings annually. They probably likely closed their case. The care and protection doesn't go away. It just goes dormant or off-listed because the parents still have a right, and the children and the department, for that matter, have rights for review and redetermination subsequently down the road if they so choose to elect to. But when the department is, as the petitioner, elects to then prosecute the parents' parental rights and then say, well, we had no obligation to work with the parents after the initial guardianship entered, well, then it stands to reason that when the analysis of those 210 Section 3 factors, which I argue that the judge didn't even make an analysis of those, and her findings aren't ones you can draw conclusions from, that the department can then say, well, you didn't engage in services, so these factors apply, or the judge says these factors apply, when a condition on those factors applying is the department had to have offered services. So it's sort of one way or the other. Either the department didn't have an obligation to offer services while the permanent guardianship was in place, and therefore a termination proceeding can't use that against the parent because they didn't offer services, or the department had an obligation to offer services, and the judge had to make a finding whether or not they did so before terminating parental rights. If that makes sense.
Your time is up, and we'll see
I know
whether
my time is up.
clarification is necessary.
I know my time is up, but there's one point, if I may.
No, I'm sorry. Do you have any? No. You can just leave it in your brief. It will not be ignored.
Okay. Well, it was about the recent case that just came out, adoption of Ariana, about the parents and their, I just wanted to bring, obviously, Jenny Lynn, you know far
Yep, we're
well
familiar.
about that case, but we just want to bring that to the court's attention. Thank you.
Appreciate it. All right, we have counsel for child number, or for the department, I'm sorry.
Good morning. May it please the court, Matthew Price on behalf of the Department of Children and Families. The department is asking this court to affirm the decision of the lower court that terminated mother's parental rights. The trial court's decision was correct. This case is about a mother walking away from her children in 2018 and essentially never looking back, and never trying to get custody in any meaningful way. She was absent from their lives, as well as absent from the court proceedings that involved their lives, and her absence speaks volumes.
Well, she did try. I mean, she filed a review and redetermination in 2022, right?
She filed a review and redetermination.
Department, she started to pursue that. Did she engage in services?
I know that from her review and redetermination motion that she was aware that the department was trying to work with her as far as services. I think that the judge was correct, and it wasn't an abuse of discretion to consider the pattern of her behavior over a number of years. And in considering that and her absence, disappearing from these children's lives, particularly how she left them, that it was not an abuse of discretion to find that the children were abandoned and terminate her rights. As far as what had changed in the course of this case, really, I don't think that the evidence established her unfitness. She never rebutted it. She had opportunity to rebut it. She did not appear at the trial in 2019. She did not appear.
He says, hey, no, you didn't establish her unfitness. He, meaning your opponent. Because we don't really, nothing was put in other than documents. Where was the DCF worker to talk about current circumstances and current attempts to meet with mother, and where was that? And why wasn't that person put on the stand?
I can't answer why the person wasn't put on the stand, but as far as meeting with mother in 2020, as my brother points out, what took place after that was the review and redetermination hearing that the children asked for. Mother was absent from that. That was an opportunity for her to step forward and make her rebuttal against the against her unfitness. She also had the opportunity after that in October 2023 when she asked for relief from judgment and to reopen the evidence, and then did not appear at that hearing either. In both those cases, the court took a negative inference, and this all falls into a pattern which began at least in 2018 when she actually walked away from these children, but I think could stretch farther back where there were issues around her.
What do you say to the argument that the judge needed to do more than just say, oh, I considered the 13 factors? The judge needed to address those factors in some meaningful way, show that the judge had considered particular factors important here, or not important here.
The statute requires that the judge consider the factors, and she was explicit in considering the factors. She did not include, she did not break out after the findings.
So if you just include boilerplate at the end of any opinion terminating a parent's rights, hey, I considered the 13 factors, you've satisfied the statute.
That she was explicit, that she said she considered it, was one thing. The other thing is, looking at her reasons for why she found mother unfit corresponds to different numbers of the
Starting with number 1. Whether the child's been abandoned.
That's one that you could do that. Also, number 6 and number 10, as far as the length of time that mother had not been involved with the children. Number 8 and number 12 regarding...
But that's really an argument. Look, she didn't address them specifically, but if you read her opinion, she actually addresses a number of these factors in the opinion itself.
Yes, yes.
Okay, so this goes right to the concern that I have here, because the Supreme Judicial Court has repeatedly said the judge must exercise the utmost care in these cases. Such care, in our view, demands that the judge enter specific and detailed findings demonstrating that close attention has been given the evidence. So there were no findings from the prior judge as far as unfitness went. The findings from this judge are very thin. Is it your position that, as thin as those findings are, that they satisfy the requirements of the Supreme Judicial Court?
Yes, because they didn't need to be lengthy. A lot of what mother's unfitness was premised on since the review and redetermination was her absence, that she wasn't there. She didn't participate in anything. Nothing had changed since she deserted the children in 2018. What had changed was the children, that their growth through childhood and their desire to separate from their parent and the parent-child relationship, that was the metamorphosis that took place. But as far as given all the opportunities that mother had, she did not make any attempt to challenge her unfitness, and the absence of her involvement, I think, reflects how the judge depicted it in the findings, and I think that it was sufficient.
I see your time is up. I'm going to see if anyone has additional questions. I see none. Thank you very much.
Thank you very much.
Good morning, members of the panel. May it please the court. My name is Laura Smith on behalf of the older child. My now 15-year-old client has been separated from the appellant for 6 years and respectfully asks this court to affirm the decree terminating the appellant's parental rights. I'd like to turn my attention to some of the questions that came up during my brother's arguments. Firstly, with respect to the trial, this was a review and redetermination trial, meaning that the evidence was built upon evidence that was presented at that 2019 trial, meaning that there was evidence taken there, and then this trial introduced new evidence. Contrary to my brother's argument, there was evidence presented at this trial that the appellant had failed to contact her attorney within the 9 months leading up to this trial. She had failed to maintain any contact with DCF in the 10 months leading up to this trial, and she had failed to visit with either child in the 4 years leading up to trial. With respect to my brother's
Where
argument,
was the evidence that she had had no contact with staff for 10 months leading up to the trial? Because I thought there were no witnesses.
that was, there were no witnesses, Your Honor. However, there in the court report provided to the court at Record Appendix 4 at page 149, there had been no contact, and
Who's talking?
the department.
So this is the department's attorney is making this representation.
No, the department's social worker in that court report.
Well, but they're not under oath. There are no witnesses.
That is true, Your Honor, and
So it's argument?
It is argument, Your Honor, and it's the judge's determination to make regarding credibility. The judge specifically discredited mother's comment that there was this video call held 3 weeks prior to that March 2022 meeting that she had with DCF. The court was free to discredit that statement and did so. There's also evidence contesting that the child herself said, my client specifically, that she had not seen or spoken with the appellant 3 years prior at one point, and her timeline lines up with the department's timeline, which is that the last supervised visit documented by DCF took place in February 2019, and that was discussed at the trial in June 2023, and the judge was aware of that. Also at that meeting, just turning to the question whether she was participating in services back at that March 2022 meeting with the department, yes, the appellant did sign releases of information. However, the department was unable to confirm any of those services because she used different aliases and dates of birth, and it made it difficult. So the evidence at the time of trial was that there had been no confirmation of her services 7 years prior to the trial. That was the last confirmed services that the trial judge knew of. Turning to the findings made by the court here, they are 36 findings here. They are supported by the evidence. The 2 challenged findings are only challenged, portions of the finding. It's not even the entirety of the findings that are being challenged. These findings are supported by ample evidence, and the court was entitled to weigh them and did so. Turning to the question about the specificity and whether the judge needed to specifically outline which factors she was considering in her decision, the statute does not require that type of precision. We have adoption of Darlene that also states that. And the findings as they're written show that the court did pay careful attention to the evidence, that she clearly read through the documents. They are supported. She's not talking about some other family or some other kids. She's talking about this family and these kids. And she had the evidence to make the determination that she made. My client spent about 8 years out of her 15 years of life with the appellant. DCF removed my client from the appellant when she was 4 years old. DCF reunified her 10 months later when she was 5 years old, and then removed her again at 9 years old, and she's remained in care ever since then. By the time of trial in June 2023, the appellant had not visited my client. The record evidence would show since 2019. For the remainder, if the panel has no questions, the older child requests that this court affirm the decree terminating the appellant's rights and rests on her brief for the remainder of her arguments.
Thank you. Just checking to make sure there's no further questions. Thank you very much. All right, now we'll have our last argument from an attorney who is appearing before Zoom for the younger child.
Members of the panel, may it please the court, Nicole Paquin on behalf of the younger appellee child, who also asks that you affirm the juvenile court's order. I'm going to try not to repeat too many points that prior counsel raised, but I do want to mention that the lodestar in these cases is necessarily the best interests of the child. And here, best interests of this child requires termination of mother's parental rights. Even if this court were to find that the department should have made greater efforts to reunify, adoption of Alona and care and protection of Rashida say that the best interests of the child can still require termination of parental rights. The court can still terminate mother's parental rights because it's in the best interests of the child. Here we have a mother who failed to appear at trial in 2019. Subsequently, in 2021, filed a motion for review and redetermination. A year later, withdrew that motion for review and redetermination, failed to appear at trial in 2023, and then moved to reopen the evidence only to fail to appear again. Right? Mother had ample opportunity to rebut the evidence introduced at trial. That evidence included not only that April 2022 court report that Mother's Counsel referred to, but also court reports from August of 2022 and December of 2022, which detail how Mother had become inconsistent with the meeting with the department as of August, and then had failed to engage with the social worker entirely as of December 2022. Knowing that was in evidence, Mother had the opportunity, after her express motion to be allowed to give evidence, she had the opportunity in October of 2023 to testify and rebut that. She failed to appear again, which is evidence of a continuing pattern of Mother at her whim, appearing in this child's life and then disappearing again. This is the kind of repeat litigation that the court can and should protect this younger child from. The child should and wishes to be protected from Mother coming and going in and out of her life. In adoption of Nancy, the court found that that is a reason to terminate parental rights, because if Mother's parental rights are not terminated, then this is sure to continue to occur. Mother is unable to meet the younger child's significant special needs, and the court, the trial judge, did make findings of this. The younger child has significant neurological, emotional, and educational challenges. She was born premature with low birth weight. She was exposed to cocaine, and she continues to suffer the effects of this. While in Mother's custody, the younger child had significant seizure activity and breath-holding spells, which Mother disregarded as temper tantrums. Also, while in Mother's custody, the younger child had dismal school attendance, and many of the younger child's significant learning disabilities were not discovered at an earlier age because she was not in school, because of her poor attendance. After the child was removed, Mother failed to attend IEP meetings for the younger child. So the evidence is clear. Although the evidence at trial was perhaps not what we would wish it had been, the evidence establishes that this younger child has significant special needs which Mother cannot meet. Mother had ample opportunity to rebut that evidence and failed to do so. Though not determinative, the wishes of the child must be considered, and this child respectfully asks that the court terminate Mother's parental rights so that she may be protected from this type of ongoing, repeated litigation. I apologize, Your Honor. I am not sure if I'm out of time. I feel like
Counselor,
I
you
may
have
be.
exactly 10 seconds. Excuse me, you can hear me. You have 10 seconds or 7 seconds, and so your time is up. I don't want to cut you off on your last 2 seconds, however. Are you finished?
Yep.
Okay.
I just wanted to say that as to any other points I have not addressed, I'll rest on my brief unless the panel has questions for me.
I will check with them. No questions from the panel. I think I can say on behalf of everybody here that we hope that you feel better, and thank you for participating via Zoom so that we can hear this case and move the case along. Appreciate it. We'll be taking the case under advisement.
Thank you for allowing me to hear by the.
We always know these cases are difficult, and they require a lot of attention on our part, and you can all be assured that we will give it all the attention that it deserves. Okay? Thank you. All right, our next case on the list is case number 2023-0739, Kevin McLaughlin versus Jane E. Bloom and trustees of the 590 Condominium Trust and others. Okay. Good morning.
Good morning. May it please the court, Patricia Gary, and I represent the trustees of the 590 Condominium Trust. Your Honors, this judgment should be reversed because the evidence fails to demonstrate the elements of a prescriptive easement from 1959 to 1979. And that period of time is really the only period that is at issue here because of the judge's ruling that the plaintiff has proven by clear preponderance of the evidence that the use of the walkway located on 590 was continuous and uninterrupted beginning in 1959, that it was open and notorious, and that it was adverse for a period of not less than 20 years beginning in 1959. And as such, the issue of tacking or a later interruption need not be and is not addressed here. So really the only period of time that we're talking about is 1959 to 1979, and that is addressed in volume 2 of the appendix at page 24 to 70. Those are really the only pages that are at issue because of the judge's ultimate conclusion.
So what was missing? There were two witnesses who testified about that time period, right?
Correct.
Mr. Fowler and Mr. McNulty.
Well, Your Honor, a prescription has to be, prescriptive easement has to be continuous and uninterrupted, open and notorious, and adverse. And your own case, Barnett versus Myro, which is a 2019 case.
I'm familiar with the case.
So even under that case, easements can only be established in either of two ways: by use with knowledge of the owner, which we don't have here because there's no evidence of any of the owners, or by a use so open and notorious that knowledge of a claim of right will be presumed. And here, there just isn't that open and notorious evidence because Fowler was only there for 3 weeks of the summer. And that's just not enough. There's,
What says that's not enough to infer, given the nature of Fowler's testimony, that this was also happening when Fowler was not present?
I think that that's one of our main points, is that inference is speculative. There is nothing to back it up. He said there was the only...
Yes, there is.
Well, the only evidence came from two witnesses saying that Majestic...
So Fowler says, yeah, I was there 3 weeks It was usually during the summer, although I think there's also a reference to him being there around Christmas time at some point. He says the weeks varied. June, July, he thinks, for the most part. And every time I went, we would walk regularly to his shop, which was on Commercial Street.
If that was credited, it's just his testimony that when he visited, they went to the Golden Gull. There's no other evidence by anyone that says that he ever went anywhere else.
Does there have to be?
I think there does, because
Why?
even...
Why is, evidence from one credible witness that this happened, why isn't that enough?
Because it's only 3 weeks of the year, and it was in the summer. It was actually not even just the summer, it was in June and July, so we're cutting out August completely. And that's just not enough, because there's 40-some other weeks of the year where there was no evidence whatsoever of any use at all.
Well,
What about?
Go ahead. No, I was just following up on Justice Inglinder's point about a fair inference. Isn't there an inference that the shop was on Commercial Street?
I don't think that that's a fair inference, because there's no evidence about the shop other than the name of it being the Golden Gull. We don't know what it was. We don't know what was sold there. We don't know anything about it. We don't know whether he was an absentee owner, and I've pointed that out in our reply brief. We don't know.
Well, we know he's not an absentee owner because Fowler testified that he walked to the Golden Gull with him.
But he could have had someone else managing the store. He could have had employees working there.
He could have.
That's a speculation, though.
Yeah.
But it's speculative to think otherwise when there's no testimony about it at all in the record. There's nothing about that store. For example, it could have been like a furniture store that was only opened by appointment, an antique store where it's closed most of the year and someone opens it 3 times a year. I know plenty of places like that are just always closed. They're never opened. And there's just no testimony when this place was open.
So, there's no testimony about when it was open. You're right about that.
Mm-hmm.
But the words "no testimony" are ones that, we can read what's in the record as well as you can. And,
Of course.
Lots of times I would be at his house, lots of times, and I would walk down to his shop, the Golden Gull, and we would go through the right-of-way and walk down Commercial Street. And then later, I think that the question is, okay, during your visits to Provincetown, how frequent were those visits? I would be in Provincetown at least 3 times a year. And during all of those times, did you have occasion to visit Jimmy Majestic and walk with him over 590 Commercial Street? Yes.
But he's the only witness, and it's only those
have to have more than
couple
one
weeks
witness.
a year.
We have cases, we have sexual assault cases where there's one witness all the time and someone goes to jail as a result.
But this is a prescriptive easement, and it's completely different.
There's nothing that suggests that one witness is not enough in our courts.
No, I agree that
Credited.
one witness could be enough if they were testifying about the whole year. It just seems it's not continuous.
Are you saying this goes to the issue of whether or not it's notorious, whether this...
Both. It's actually both issues, whether it's notorious and whether it's just too sporadic and infrequent to be considered continuous.
Can I ask you about the pathway itself? So who put in the pathway?
I don't know that, and there's not evidence of that.
Who maintained the pathway?
There's no evidence of that. That would all be speculative as well.
And did anyone make any alterations to the pathway over time?
Again, other than the incidents that engendered the lawsuit.
Right, apart from the fencing and all
No,
that.
in this period of time that we're considering, that 20-year period, there's just very, very sparse evidence of anything.
And it looks like it's a pathway that has like wooden
It
planks.
has a gate, and everyone agreed to that there is a
pathway
gate,
itself,
a
what's it
locked
made
gate.
of? The pathway itself, what's it made of? Is it wooden planking that goes
There's
over sand?
There's photographs that show different things. More recently, I believe there's planking. Fowler testified that it was gravel.
Sand and grass,
sand.
I think.
And do we know who put that in?
No, there's no evidence about who put it in or how it changed. The only thing that's consistent throughout is everyone agreed there was a locked gate that went out to Commercial Street, and that's evidence of control over that pathway. So the owners, all of them, exercised control. Now,
Was it locked? Was there testimony that it was locked during that 20-year period?
Yes, it was locked. In fact, Dorothy Maury, who is one of the witnesses.
There was no evidence that you couldn't pass through the gate by opening the latch.
Well, she said that it was a locked gate. And she said that she had young children, and that's why she was concerned. And actually, my client has young children, too.
Said it was a locked gate.
Yeah.
Excuse me?
Who said it was a locked gate?
Dorothy Maury said that she had.
Who arrived in 1980.
Right. I don't think that she's relevant to the 20-year period, but I'm just saying.
So let's go back to that. I believe I heard you say that during the relevant period, 1959 through 1979, that there was a locked gate. Did I hear you say that correctly?
Not during the time period that there's the only evidence is by McNulty of that gate. Fowler says, at first he says, I don't remember a gate, but later on he acknowledges that he does remember a gate.
My recollection of the record, and I want to be sure that it's correct, is that there was no locked gate that you could pass freely during that 20-year period.
The evidence would suggest that, so I don't have any other evidence other than McNulty also acknowledging that there was a gate there. He also, everyone is in agreement that there was a gate.
I think the essence of this position, the way I'm hearing it is, you can't have someone come in and testify about 3 weeks a year and extrapolate from that it was used continuously for the entire year, right?
That is our position.
Do you have any cases that say that? Where would you point us?
Okay, so I'm going to just quote the case, and this is your case, the case that Barnett versus Myro. It is the general rule that prescriptive rights are measured by the extent of the adverse use of the servient property. Quotation and citation omitted, Tinker versus Bessel, and that's a 1912 case. Intermittent and irregular use is insufficient to meet the plaintiff's burden to prove an easement by prescription. See Boothroyd.
Barnett against Myro is a case that holds that they had proved prescriptive rights. I mean, do you have a case where someone said, this proof is insufficient because it's too inconsistent, it's too... And if so, where would you point us so that we can see what a court has said is not enough?
I have a lot of case law that says that. I don't have one at my fingertips right now it is on point with the facts here, because there's an awful lot of the case law that has seasonal use. For example, going to
seasonal use can be enough.
Yes, and so what
you're talking about, even though it's almost by definition intermittent or not continuous, right?
In fact, in that Barnett case, we're talking about beaches.
Mm-hmm.
So for beaches, that's completely different because it is seasonal, and there you can have weekend use, or you could have just the use during the season of the summer when people are using a beach, and that's enough. But that's a different use than what's at issue here.
What case says that? Because, so I could understand an argument that said something like this. Look, if the Golden Gull was only open in the summer, because we are talking about Provincetown, he only used it during the summer, his rights were limited to using it in the summer. I could understand an argument like that, but does any case say that?
I mean, most of the cases on this very sporadic intermittent use is seasonal, and it's for something like a beach. I mean, I looked for cases, I couldn't find any because the general rule is that won't be enough. It's only going to be enough if it's for something seasonal, using a lake or something that's not going to commercial.
No, the problem is over what does intermittent mean and who gets to decide whether something is intermittent and what evidence is sufficient to show that it's more than intermittent. That's where the case law would be very helpful.
I guess what I'd like to also point out is that the judge clearly erred with McNulty's testimony as well. So there's just some clear errors, and I really want it's important to point these out. For example, this testimony or the judge's finding that McNulty regularly saw people walking across that right-of-way, that he calls it a right-of-way, including Majestic and his partner, Tony Simmons. And that is on...
Right, and his partner's name wasn't Tony Simmons.
No, but that's not all. That's not all, because McNulty actually testified, and I didn't put this in my brief, so I should have, but I didn't. McNulty actually testified it was only in the later portions of the 90s, maybe 1990 on, that Jimmy Simmons would venture off the property. That's volume 2 of the appendix, page 49. He rarely left the property on page 50. So the judge got it wrong. I mean, when McNulty testified about Simmons, he said he barely ever left the property, and it wasn't until the 1990s, maybe, that he would venture off the property. And then the only thing he would do was go to the beach, which is not going down Commercial Street. So,
well,
but I don't know that that matters.
He's a little inconsistent about dates when it comes to him.
But he was very clear about Jimmy Simmons' use, and he was really talking about someone else. He was not talking about Simmons. He was talking about a different partner. So, and that partner was from 1975, on, and he says that when I got my driver's license, I would take Majestic to visit him. So that partner was only for 5 years at the most, when he was a teenager. And I mean, I read the testimony very, very, very carefully to pick these things out. The other place that the judge got it wrong is that he makes a conclusion that McNulty grew up in, or a finding of fact that McNulty grew up in Provincetown, living there from 1971 to 2001. But there's actually cross-examination that says, so you did not live at Shipsbell from 1998 to 2001. And McNulty agreed, no, I didn't. I bought a house on Priest Road in Truro with my wife in 1998. So that's an error. There's
We're talking about 3 years, the three years.
Yeah, but
and he
it's
was
just
working.
there's
He was
just-
working at the same house. He made that point in the next sentence of the cross-examination.
I mean, he says that, but...
What do you mean he says that? I mean,
Well,
there's sufficient evidence for a judge to make a finding. I
the
think you're
judge did
arguing
make
clear
an error.
error, aren't you?
I think the judge made the biggest error by talking about regular use by Jimmy Simmons, because that's just not correct. And then he also...
Okay.
Counselor, your time is up.
Do you, can I?
Yes.
One of the arguments that you've made, which I confess I don't fully get yet, is that they did not, the plaintiffs failed to prove who owned the walkway. Words to that effect. That was the argument that was made in your motion. Are you continuing to press that argument?
It's in our brief, and we definitely briefed it. I would say that there's 2 points to that, and that in Section 8 of Chapter 231, the Declaratory Judgment Act, you need to name all of the interested parties in a complaint.
Yeah, that isn't the argument you made to the trial court, though, is it?
It's very similar, and she did continually say that.
I don't think you mentioned the need to name all the parties or the Declaratory Judgment Act in the, may I, in the argument you made to the trial court. If you did, I need to understand that. I thought the argument you made to the trial court was you failed to prove your case because you did not prove who owned the property.
I believe that she said that if you read the whole motion,
there is a reference to the need to name the other parties?
yes,
Okay.
there is.
All right,
All right.
we'll check.
Thank you.
Thank you. Let's take a look.
Good afternoon. May it please the court. My name is Attorney Christopher J. Snow. I represent the appellee, Kevin McLaughlin, and I'm from Provincetown. Live actually not far from the neighborhood involved in the locus of this case. I think it's, I'll speak first to the 1959 to 1979 issue. I think we're dealing with clear error and credibility of witnesses. We have a period here that spans over 60 years of testimony that the judge took in and could consider in terms of the periodic use during that 1959-79
It has to be
era.
continuous, right, for 20 years?
That's correct, but we have
Would periodic be sufficient?
Well, we have filled that gap in terms of periodic with James McNulty, who had a bird's eye view, at least since 1971, of the goings and coming, which is much more expansive.
8 years of the 20-year period, McNulty is present, right?
He is.
He's 9 years old in 1971, though.
Very observant 9-year-old.
Well, he actually said I was a teenager, so I wasn't paying really careful attention.
He wasn't paying careful attention, but he was right next door and had an unobstructed view and became quite
How
friendly.
does he fill the gap? Where should I look in his testimony, which I have right here, for him filling the gap?
Basically, he states that he observed Majestic traveling to and from Commercial Street from his vantage point right next door over his entire, not only from 1971 as an 8-year-old, but actually as an adult. He is consistently stating that he observed those travels of James Majestic, not so much Simmons, and great emphasis on Simmons. Simmons, as we know from the record clearly, was a recluse, and he hardly came out. He was very shy. They called him the inside-out man because he wore his clothes inside out. There was robust testimony as to McNulty's observations, unblocked, unadorned, that he was quite emphatic about. I know that there was some issue of his statement of permission, but that has no bearing, even if you were to credit the appellant's argument.
Actually, not what, I mean, you say it fills the gap. I'm reading it. By inference, it fills the gap, but there isn't that direct question that says, how often did you see them use it?
I got the sense, Your Honor, in the tenor of not only his testimony, but virtually every other witness's testimony. Dorothy Mowry, James Turner, Tony Sampson, all of the witnesses were consistent with the regularity with which Mr. Majestic, during his lifetime and shortly before he died, with the assistance of the immediate predecessors and title of our client's property, traveled to and from Commercial Street. And they were detailed observations and detailed testimony as to how they traveled, where they traveled, whether it was to the retail Gulf store or not. Commercial Street is a major thoroughfare. It's their access to it. I also noted that you had a question about who built the boardwalk, as it were, or that. I think that you can find in the record from Dorothy Mowry's testimony when the condominium was converted by her then husband and stepson. They built a wooden walkway, which I believe still exists, but she emphatically stated that she actually thought that Majestic and the owners of 283 Bradford Street had a right and acknowledged that. And it was not a matter of permission that she was even thoughtful of giving, because she just assumed, based upon the conduct of the use by Majestic and his friends over that right-of-way, was continuous.
Let me ask you about that. So if they built the pathway, presumably someone then maintained the pathway, and it's used by others who don't own the property, it's used by others as a pathway, what's the how is that adverse? What's the adverse use here?
Well, after the 20 years, it's presumed to be adverse.
That's all you got? There's no...
Well, there's an obligation of the landowner at that point.
I mean, it's a rebuttable presumption.
Correct, but there was no evidence to rebut that it was anything other than
Well, how about
adverse.
just the fact that it's built as a pathway? That in and of itself, doesn't that suggest it's available to people to use as a pathway? So it's not, it's, by its nature, it's not an adverse use. It's not like someone's driving a truck down it. It's meant for people to walk over, and it runs the whole length of the property, which suggests that it's open for people to use as a pathway.
I don't quite get it.
I'm just wondering what the adverse...
And the adversity is that the property owners have subjected themselves to the passage of people that are alien to their title.
Yeah, but I'm just thinking of, I mean, if, just as an example, let's say I have a large backyard that I maintain, I cut the grass regularly, but my neighbor's children play baseball in their backyard, and their center field is in my backyard, and this goes on for 20 years. I never say anything about it, they never say anything about it, but I maintain it as just an open backyard. It's not in any way adverse to how I'm using the property. Would that qualify as adverse possession?
I think so, and I do believe it would qualify, because what you're doing is taking away the element that is absent in a prescriptive right case of exclusivity. Here you have a common use, and a common use of, at least from the party that doesn't own it, of somebody else's property. That per se is adverse, unless it's accepted by permission.
Well, it might not be adverse possession, but it might have a prescriptive easement to continue to play baseball.
Correct.
The path, as I understand it, there was parking behind 590, right? So the path could be used as well by people parking at 590 and walking out to Commercial Street, right?
That parking, as I understand it, and I don't believe it's in the record, but I happen to know that parking is exclusive to the 590 Commercial Street condominium, five-unit condominium.
But my point is that the walkway itself could be used by people who are visiting 590.
That's correct.
Okay. You know, one of the things that struck me, just for future reference, it would have been great if some of the exhibits that actually showed the layout of the land had been included in the brief, so we didn't have to chase around the record to find them, because it's really hard to understand somebody describing how real property lays out. But a picture's worth 1,000 words. Okay. I want to switch gears for a moment, if we can. Maybe you can help me with something that is not raised by the other side, and I recognize that, but that the judge references, which is, why is the use pertinent to the property as opposed to a use by Majestic? I mean, it seems to be sort of assumed here that the right passes to your client because he buys 283. Why is that?
Because the right vested to Majestic while he owned the real estate. And by virtue of that vesting...
Is there a case that says this?
I think that is elemental, I think.
I don't think it's elemental, because all I have to do is ask you the hypothetical about the person who lives 2 blocks away. Does that mean that his house 2 blocks away now has a right to pass over 590 if he regularly used the path?
I believe he does.
Really?
I believe that right vests and runs with the land. And I think that's a correct statement of law. I don't...
You think that's standard prescriptive easement law?
I do.
Okay.
Which can actually convert to a public. If a great number of neighbors and a whole neighborhood starts doing it,
but then
all of a sudden you have
that's
a public
right, not a right that's specific to a piece of property. Okay, another question along the lines of the last question that was asked. Did you prove who owned the property, and did you have to prove who owned the property?
I believe that the deeds are part of the record, that that are part of the exhibits, but I don't think that
What does the deed show?
Well, the deed, I believe, shows the ownership.
590 condominium trust?
The most recent one would be the individual unit owners, and the unit owners converted to the master deed, so that the master deed would
The master deed
of the
is
present
590 condominium trust?
would be the present operators of that real estate. They manage the real estate, so that each. I'm sorry.
So, you know, well, no, but I mean, this
master-
argument's been raised, and we're going to have to deal with it, right?
Right.
And the judge didn't address it, and as far as I know, you didn't address it, so we have to figure it out. So so my question is, if the path is common area to a condominium, which I think is your position.
It is.
You wrote it in your brief, but I'm not sure there's any evidence to that effect. How do we know that? How do we go about thinking about this?
Well, that issue first came up after the trial and after.
But if an argument is at the close of the evidence, you didn't prove your case, that's an argument you can make. Unless you're telling me that they were precluded from raising a new issue because they didn't raise it in a pretrial memorandum and there was some order to that effect or something. Otherwise, it's basically an argument that says, look, you failed to prove your case, Judge.
But that was not made at the closing argument. She had finished her closing argument. The second day of trial was necessitated by...
You have post-trial briefing?
There was no post-trial. The case, our position is that as soon as the appellant closed her case and said, thank you very much, you must deny the plaintiff's relief.
And she can't raise another issue that's basically you failed to prove.
Not without a post-trial motion. She sheepishly, when the judge was getting ready, we were all packing up to leave, all closing arguments, all evidence was closed. This case has been 6.5 years in the making, and
I understand your point. I'm just trying to understand it, because I have to say that I would think that at any time before judgment, you could make an argument to the judge by filing a brief or a motion that says, Judge, this is an element of their case, and they didn't prove it.
I think there would have to be a motion duly noticed to the other side so that we would have an opportunity to address that.
Was there
and
no
such
motion?
motion was ever served upon me other than a blank, unsigned motion unceremoniously handed to me on the way out the door.
It says motion for partial finding. That's what the motion is entitled.
It's entitled that.
And I understand at the transcript exactly that it was brought to the judge's attention and then not really ruled upon. And you're saying that that was when you received a copy of it.
That's when I received the only copy of it, unsigned, and simultaneous with when the judge received it. I don't know whether that was a signed motion or not.
Well, let's assume for now, you've got a procedural argument. Let's assume that it's not decided on the basis of a procedural argument, and we have to get to the merits of the question. How do we think about that? I'll give you some thoughts. One of them is the defendant trustees were sued because they locked the gate. That seems to me to be reasonable. They're the defendants who locked the gate. We need an injunction against them to unlock the gate. So you got the right defendant on that one. I get that. But how else should we think about this?
Well, if you look at the condominium statute and the actual condominium here, the trustees, two of whom were the only two who were named, and very significantly are also co-owners of at least 3 units in a 5-unit condominium.
Okay.
They basically control from that perspective.
How do we know that, though? I mean, I looked at the complaint, I looked at the answer. How do we know?
Well, I think that from our perspective, at post-trial notice of this for the first time issue, that it should have and must have been an affirmative defense, or at least brought up in terms of a motion to dismiss or failure to misnomer of a party. There was a duty on the defense of that case and the appellant to notify not only me but the court, rather than squander the judicial resources for 6.5 years.
Where does the duty come from if it's just proof of your elements of your case? I understand if it were like a necessary party kind of argument, yeah, that makes more sense to me. That's got to be raised by them. But if it's simply, look, an element of the case is proving who owned it. In order to get a prescriptive easement, against them as the owners, which I guess would be the argument, you needed to prove who you were getting the prescriptive easement against.
I believe the deeds are in the record, Your Honor, in terms of the 1959 to
And
the 1979
the argument is that if we look at those deeds, we will be able to determine that the trustees, who were the defendants, were the proper people to represent the owners under the deeds. Is that the argument?
Correct, because that particular prescriptive right vested in 1979, and no matter how many condominiums or who else owned it thereafter, that ceded to the 283 Bradford Street at that time and date and was binding upon whomever owned the property.
Okay.
Okay. Thank you.
Thank you both very much.
Thank you.
Thank you for your arguments. Okay. Now have our last case of the day today, which is case number 2023-0708. David Fossa versus Daniel Tsai. Please tell me if I pronounced that name correctly.
May it please the court, John Ford from Northeast Justice Center in Lynn, appearing on behalf of the appellant David Fossa. Excuse me. This case began early in 2015 when, at age 51, David suffered a medical catastrophe that left him mentally and physically incapacitated. After months of hospitalization, he was admitted to the Prescott Nursing Home. And in March of 2016, the record shows that he was qualified for Mass Health long-term care benefits with an effective date of July 2015. He went home briefly. He was actually hospitalized from the nursing home, and when he was ready to go back, the nursing home didn't have a bed for him, so he was admitted to another nursing home, Rosewood, in May of 2016.
I don't want to interrupt you, but we can, I think, move to this. The period of time that we're concerned about is only May 26, 2016 through October of 2019. Is that right?
That's correct, Your Honor.
Okay.
So when Rosewood billed Mass Health for his care, Mass Health didn't pay the subsidy and instead required David and Catherine to submit a new application. And they basically said that you have to give us information about interest that she had in several LLCs that were owned by her employer, the Richmond Company.
So I think, you've been sitting here for a while, counsel, so you know that we've read the facts. So why don't we jump into it? So why is it that there was error here in failing to find, your argument is it was error, that the judge should have found that these were inaccessible, right?
Correct, Your Honor.
Why is there error?
Because it's not based on the evidence that was presented. I would call the court's attention to the transcript of the hearing that occurred on April 2020. There's testimony from page 38 to 50 from Andrew Burek, who is the general counsel of the Richmond Company. He testifies as to the nature of the interest that Catherine had in the LLCs. And he describes how the sort of environment of LLC real estate environment, and says that in conclusion, and I quote, Catherine could not liquidate without totally selling and dissolving the company.
Well, but that's not true.
Yeah.
That's just not true, and maybe that's part of the problem, because she could sell or transfer the assets to somebody else and monetize them.
No, that's not what his testimony is, and in fact...
Well, why do we have to accept that?
I'm sorry?
Why is that testimony the controlling factor here?
Well, it's evidence that was put in, it was probative evidence put in as to the nature of her interests, and it was not rebutted, and it was not even analyzed. There was no findings of fact, there was no conclusions of law with respect to...
But there are in our Superior Court. The judge, for the first time, as I'm reading this, of course, I'm asking myself, geez, I wonder exactly what these documents say. They're not in your brief, they're not in the Commonwealth's brief, but they are in the Superior Court judge's brief. And the Superior Court judge analyzes the documents, and he says, or I think it's a he.
She says,
it's Judge Buxton, do I have this right? Yeah, Judge Buxton, who says, they are transferable, at least some of these, with respect to some of these, based on my reading of the operating documents. And that's enough. And that's what she says. Now, why is that wrong?
Well, because it is not based on the evidence that was put in the fair hearing,
Wait, weren't the operating agreements put in as evidence?
Yeah, the operating agreements are there.
So that's what the judge is relying on. The judge looked at those agreements.
Yes, she did, Your Honor.
And said that there was both that these assets were accountable and accessible because they could be transferred. They were subject to being sold, at least the first three. And she went through all six of them, the last two not having an operating agreement, and said that the high bar, basically, of that you would have to show, which is no legal access, was not met. Because looking at the agreements here, your client's former wife had this interest that could be, I'll use the term that Justice Englander used, monetized.
So the Mass Health's position is that personal property is accessible, and interested in LLC is accessible, and that's the ballgame. And it really requires that there be an analysis of whether, in fact, her interest can be accessible. That is, convertible to cash and used to pay for her husband's nursing home care.
I think we get it, and just assume I agree with you that it's not enough to say, oh, it's personal property. That's not enough. You have to analyze the particular the particular asset. Let's call it an asset. Okay, I know that you want to suggest it's income, but let's call it an asset for now. That's what the judge found. You have to analyze a particular asset. Didn't the judge do that? She looked at these operating agreements and she said, looks like it can be sold or transferred and therefore monetized. Yeah, there are all kinds of restrictions on how you do that. But, I mean, the language of the reg is that it can't be monetized at all. And I'm going to give you the exact language because I wrote it down. It's no legal access. And so basically what she's saying is you have not met your burden of showing me that there's no legal access, no way that this asset can't be monetized through sale or transfer.
Right. And I submit to you that she has an obligation to look at the testimony from the expert witness who knows more than we do about the nature of LLCs in real estate development. And he says that in order to get access to money to pay the nursing home bill, those LLCs have to be dissolved. Well, and his testimony at least has to be either rebutted.
That's a conclusion, respectfully, counsel. That's a conclusion. That's all that is. He's saying, oh, I can't do it that way, but I don't understand why that follows from the documents, and I don't think that the judge understood why that follows from the documents either. And if she can't understand why it follows from the documents, she doesn't have to accept what the expert says.
I think that the court's position is the conclusion. I think the court definitely has an obligation to consider the testimony that was put in and it was never rebutted. So it has to be either responded to, make a finding of fact. If this testimony is not credible, what's incredible about it? In
But
fact,
that's not necessarily, not necessary, to put it simply. Given the judge's conclusion and her reasoning, isn't it clear that she did not accept that expert opinion?
no, I don't think it's clear at all that.
Well, she ruled that these particular LLCs are actually accessible and said that the bar of no legal access was not met. So
And-
that's rejecting what the experts said.
What I'm saying is the expert said that it is not accessible, and the
That's a conclusion. So let's try to dig down, because I understand your argument, but I want to really understand it at the level of evidence. FOSSA also contends the LLC interests are not marketable. There is no evidence in the record from which the court can make such a determination.
not marketable. We can't prove a negative.
If they're marketable.
If they are marketable.
If they're marketable, then this case is over from your perspective.
If they are marketable, yes. And
Okay.
the fact, and the evidence from the expert, from Mr. Barek, who's the general counsel to her employer, who owns the LLCs, says that they are not accessible because they cannot be liquidated and used to pay for David's nursing home care.
Isn't that fly in the face of the operating agreements, at least with respect to 4 of them? Or at least maybe expect to 3. The 4th one is a little more limited.
So Mr. Barek is interpreting the operating agreement. I don't know if he wrote them, but he was certainly very familiar with them, and has concluded. And the fact that she hasn't been able to liquidate them even to this day seems to me to be clear evidence that they were inaccessible.
She no longer has to, because they've been divorced, and so there's no longer any concern going forward.
No, there's
about
3, I'm sorry, Your Honor, but there's 3 years of nursing home bills that have to be paid. As a
Okay.
result of this action, my client, Mrs. Catherine, has an obligation to pay those for those 3 years at $300 a day.
Okay.
And it is my client is definitely prejudiced, by the conduct of Mass Health. I would like to also, please, if I may, get to the issue of the amended complaint, because the motion court gave short shrift to the amended complaint that we filed, raising issues of a constitutional nature.
Before you get to that, let me just ask you this quick question, because I'm very sympathetic to what has happened to your client. It's a terrible situation to be in. But we have to deal with what the SJC has told us, and there was a case actually that came out earlier this year, Dermody versus Executive Office of Health and Human Services, and in it, the court noted the Medicaid program is designed to provide health care for indigent persons. Individuals are expected to deplete their own resources before obtaining assistance from the government. And there's some other language in there too. But is your client indigent?
Absolutely. My client, David, absolutely is indigent. And the purpose of MECA was to avoid the impoverishment of the community spouse. And this is what, if Catherine did not divorce David in 2019, she would own the nursing home probably $1.5 million. So we are here today.
If she had it, if she had it, because the question is whether or not your client was destitute or impoverished on May 26th of 2016.
Right.
Clearly, the community spouse would not be paying $1 million+ if the resources had been depleted. I don't know if she has more than the $387,000 that were in the LLCs, but at a certain point, that wouldn't be the case.
But the Mass Health's position is that this $300,000, which is theoretical, the $300,000 from the record you can see was a figure that Mass Health demanded that they assign a value to these these interests in the LLCs.
That was not disputed, is that right? The actual value of those are not disputed.
The amount was not disputed. Was disputed time and again, was disputed was whether they're accessible, whether they can be
I understand
converted,
that.
liquidated, and so on. And the evidence overwhelmingly is it cannot be. But I would really like to get to the amended complaint, because when I got this case after the second fair hearing decision, and we realized that when David was approved in 2016, his eligibility was never terminated. It is a basic precept in Medicaid law that if you're going to terminate someone's eligibility, you have to give them written notice, the reasons for the denial, and a right to appeal.
I want to cut through all these arguments that you've dominated constitutional arguments. The other side says you're not prejudiced because she had the same amount of money in 2015 as she had in 2016. So if you go back and you make the determination properly under a proper record as of 2015, then she would have been denied for the same reason.
And I suggest that's wrongly stated, because the question is, did she have accessible money? Did she have accessible assets in 2016?
But that was issue number one. You've flipped over to issue number two.
They're integrated. It's not. They are two separate issues, but they're all. What they show, to my view, is the inappropriate action of Mass Health. We're challenging the regulation that says that Mass Health can do a second assessment of spousal assets after the most recent admission of a 30-day continuous period of institutionalization.
The question there is whether the federal statute prohibits that, is in conflict. I have trouble finding that conflict, but you're...
Okay, well, the conflict is...
Your time is up, but before you rest on your brief, I just want to be sure that your question was all answered. Okay. Did you have a further question? No. So you have, your time is up, so yeah,
thank you.
By 30 seconds. Okay.
Good afternoon, Your Honors. May it please the Court, Grace Golke, Assistant Attorney General, appearing on behalf of the Appellee Mass Health. We would ask this Court to affirm both the Superior Court's entry of judgment for Mass Health on the 30A claim and the dismissal of the declaratory judgment claims. This case is fundamentally about an application for benefits that was incomplete, and when Mass Health finally obtained all the relevant information, it determined that the applicant was not eligible based on excess assets. That determination is reviewed here under the highly deferential standards of 30A, which apply, I think, with particular force here, where the agency is weighing competing evidence between the statements of
What is the competing evidence?
Well, I think the statements of counsel versus the operating agreements. And the agency here was well within...
But I don't think that counsel said anything that was inconsistent with the operating agreements, did he? He said, look, as a practical matter, she can't get this money out.
Your Honor, he did say that she does not have the legal right to liquidate her interest, and I think that's flatly wrong based on the operating agreements. I mean, ultimately...
Where do you find the right to liquidate her, a practical right to liquidate her interests in the operating agreements?
The operating agreements...
I mean, there are two or three where, like, but they don't add up to $137,000. So let's leave those aside, because you gotta. There are only a couple of them that we really care about, because they're the ones that go over the threshold, right?
Yeah.
And so, in the ones that go over the threshold, where do you find a practical right to liquidate and get value out of those investments?
So, Your Honor, these are cited by the Superior Court, and it's section for the. For, I believe, Richmond LEB Self-Storage and Richmond Woods. In both of those, or I apologize, it's Richmond LEB and Richmond Woods.
Okay, so I'm on page 3 of her findings.
Yes.
Where
let
she
me-
lays out the operating agreements language.
Let me just look at the same document. And it's,
No member may transfer his, her, or its interest in the LLC unless such transfer shall have been previously approved by the manager.
So it's subject to review.
and I apologize, Your Honor, I just got there. Are you looking at, you're looking at 8.01?
Yes.
So then but it says, except as provided in sections 8.04, 8.07, and 8.08. So if you go to the next page and look at 8.04, and you look both at A, but particularly at B, B includes that a member of the LLC may, sorry, I'm just trying to skip
Yeah,
that.
so A says he can transfer to a member, and B
Right.
says you can transfer outside of the membership, but you have to give a right of first refusal.
Precisely, but that if the non-selling members do not opt to purchase, that the bona fide cash offer, the selling member has the right
To
to make
sell.
that, to sell, to
Yeah.
engage in that
And what
bona
if there
fide cash
is no
offer.
market? What if they cannot be sold? What happens then?
If the applicant could truly prove that there was no way to gain monetary value, I think that probably would meet. It's not in the regulation, but not in the state regulation, but in the federal regulation that Mass Health looks to when there's a gap. There is a suggestion if there's truly no marketable value, that would be considered not countable. But we just don't have that here.
Practically speaking, if I may, what happens then? The Brothers Council, clients have to go back to Mass Health and reopen it and ask again, say, I've tried to sell this for 2 years and I can't do it and I can't access this and I can't borrow against it because no bank will give me money against this interest here. Then it would be reopened and reviewed again? Is that how it happens?
Well, I think typically that would have been done in the first instance. I mean, here we had many years where this information was requested and it sort of came in trickles until the actual operating agreements were offered many years after the initial application. Generally, I think...
Really, when did you get, so the original application is 2015?
That's right, and then there was...
When did you get the operating agreements?
The operating agreements came when the case went up to the Superior Court once and then came back down, I believe, in 2020. And that at the time it went up to the Superior Court the first time, the Mass Health did not have the operating agreements. It was only once it had gone back again to the Board of Hearings, which I believe was in 2020.
But none of that's really pertinent here, because there was a settlement and there was a decision made that there was perhaps, to say, some missteps prior to that, but then as part of the agreement to go forward was, we're starting May 2016, May 26, 2016 to October 2019, sort of fresh slate, right? We're looking at it again. Let's see whether or not there's any countable assets.
Yes, that's right, Your Honor, but I do think from the practical standpoint, it is relevant that the community spouse here would have known now for several years that these interests were going to be an issue, and if she was able to prove she had made good faith efforts to sell them and there was simply no market available, that is evidence she could have offered, and she didn't. She said that she was legally...
I guess I'm asking a hypothetical question, that is, if a time comes when the hearing officer and then under 30A review, the decision is, those are countable. And then okay, now I've lost my case. I thought that they were not accessible. And then you try and do something with them. There is an avenue to go back, is what you're saying to me.
I don't want to speak out of turn. I don't know procedurally precisely what would happen in that scenario.
Okay, all right.
I imagine there is a mechanism. I'm just not familiar with it since it wasn't...
It's not pertinent for this case anyway. Thank you.
Let me just ask you a hypothetical. So just to simplify it in my mind, taking it out of the LLCs and so forth, what if it's just a mom and pop operation where they run a bakery and they employ, half a dozen people, and it's their shareholders in it, each own 50%, something catastrophic happens to the husband, the wife tries to carry on with the business, would she be required to shut that business down and to lay off all those people and liquidate just to get under this $2,000 limit?
I don't believe so, Your Honor, because there are separate exemptions for business expenses and assets that are related to your business. So if that person were the business owner and had assets that were related to her operation of the business, those would be non-countable under a different section, not the inaccessibility, but the non-countability section.
So why wouldn't that section apply here, or was that rejected, or?
So there was a passing effort to invoke that section. However, the record reflects that the Community Spouses Council said these interests are not part of the business. They're not part of the Richmond Company, which was her employer. They're a separate investment opportunity that she sort of gained through the business. Exactly, a fringe benefit that is not relevant to her business, to her employment for the Richmond Company. So that's why it's a difference here, is there was no showing made that it was a business asset as opposed to a benefit that she had received by virtue of her employment, but that is now a separate personal property asset.
And also, was there not an issue whether or not it could be counted as income? And that's also considered under a separate regulation, if I'm not mistaken.
That's right, Your Honor. Income is considered separately, and there is a distinction here between if
They say if it's her income, it doesn't count.
Right, and there's
Are they right?
That would be correct. Okay. The issue here is that there's a distinction between an asset that can generate income and the income. So, although this asset may generate income to her, that income as it is coming in wouldn't be counted, but the asset still exists itself as something that could be sold under the conditions of the operating agreements. So just because it generates income does not mean it itself is income. And I would point the court in terms of just the hearing, or the Board of Health.
Don't you think that the hearing examiner should have addressed the testimony of the general counsel?
Well, Your Honor, I was just about to point you to, in Record Appendix 1 at 441, that was an email exchange between the hearing officer and counsel. It came after the hearing, so after that testimony had taken place, and the hearing officer specifically asked the Community Spouses Council to address the operating agreements and said, I believe these sections of the operating agreements contradict Attorney Burek's testimony at hearing. So although that particular statement wasn't incorporated into the final decision, there was an indication that she believed there was a contradiction.
She asks them to address it?
She asked them to address that in their memo.
Basically, this is post-hearing, the hearing officer reaches out to counsel and says, hey, I'm looking at the operating agreements. They don't seem to be consistent. Can you address that?
Precisely, Your Honor.
Were they addressed?
So I would say they were not addressed in full. There was sort of a reference just to that 8.01 that there are certain restrictions, but it never addresses the 8.04, the situations in which...
There is a response.
Yes, Your Honor. That's the community spouse memo, which starts at Record Appendix 1, 407. And the response starts on 416 is the response to this particular section, and it just repeats essentially saying, there's no market for this stock, but there's no citation to any evidence. It's just essentially repeating the testimony that was given and saying they're subject to these various restrictions, but not actually engaging that language about the right of first refusal, about the right to transfer to family members, all of these various ways that at least prima facie exist for her to liquidate these assets in some capacity. There's no response to that beyond, but she can't do that. So I think the hearing officer reasonably looked at that and said, that to me does not explain the operating agreements and why they don't mean what they say they mean.
There are two components, as you point out in your brief, to the subsequently added amended complaint. One of them is a due process argument that says basically she needed pre-termination notice and an opportunity to be heard before termination. And you say not a subject of a DJ. Let's leave that one aside. Second argument is there's an inconsistency between your state regulation and the federal statute. You say you can't get a declaratory judgment on that. How can that possibly be right?
Your Honor, it's because of the facts of this case. Not to say no one can bring that declaratory judgment claim, but, I mean, and putting aside the merits of it, which I do think there is no conflict, but if we just take who can bring that claim, it really isn't squarely presented by the facts of this case, because the assessment was made as of the assets in 2015. That's what Mass Health was trying to find this whole time, was what were the assets as of the application. There weren't two assessments of two different sets of assets. That, I think, is what opposing counsel is saying. If Mass Health had done that, that would be the problem.
Different argument than the one you have in your brief. That's an argument that basically it's sort of along the lines of it's a no prejudice kind of argument. We don't really care whether they don't conflict, judges, because the issue for us was at the first time it was supposed to be assessed in 2015, did she have accessible assets in excess of what could be excluded, right? That's your argument?
Yes.
Okay. Because there was another argument in your brief, and I don't think it was right. Because I can't see how else they can challenge that, because you actually have a reg that takes the position that the hearing officer can't address whether there's a conflict and whether it's an invalid reg, right?
I think it goes to both points because the challenge.
My point?
I do, Your Honor. I do see your point. I think
that seems completely, as the Attorney General of Massachusetts, to take the position, on the one hand, the hearing officer can't address this question, and on the other hand, it can't be raised by declaratory judgment. Sounds to me like you're saying no one can raise it.
No, Your Honor, we're not saying that. I think what we're saying is, in the facts of, under the circumstances of this case, that claim, although it's purporting to put forth a constitutional issue regarding this conflict, what it's really saying is the same thing it said before. I think
It's really not a constitutional issue under Section 1983, by the way. It's a supremacy clause argument. That's all it is.
Yes, Your Honor. And I mean, I think regardless, the prejudice argument is grounds for this court to affirm. So I won't push that further here.
Understand your argument. Thank you.
Thank you, Your Honors.
No further questions. Thank you both very much. We appreciate it. All right, thank you everyone who's helped us with today's hearing. We appreciate it, and the court is in recess.